Item number 1, just to remind your Lordship, order dated 17th of August 2022. I have given an order. Your Lordship would kindly accommodate one order. I have given copy of one just order that the matter is pending before the Honorable Supreme Court of India.
Okay.
So your Lordship may adjourn this matter signed till the matter is disposed of or decided there.
All right. It is stated that the SLP Civil 12313 of 2015 still pending the Supreme Court. The present writ appeal is adjourned sine die, awaiting the decision in the aforementioned SLP. After which it will be open to either party to mention the present appeal for listing.
Old matter item number 2.
None appears, Mr. Napas.
Item number 3.
None appears.
Supplementary list item number 4.
It's not maintainable, my Lord. Let's dispose.
Counsel for the it's as the appeal is not maintainable.
Supplementary item 5.
May it please, my Lord. My Lord, the allegation was that the inquiry, departmental inquiry, was conducted in a lopsided manner, my Lord. And no adequate opportunity was given to the delinquent to defend himself properly. One of the allegations was that he was denied defense assistant. The second is that 3 witnesses whom he wanted to examine, they were bank employees, but the inquiry officer didn't summon them, and therefore they couldn't ever leave and come. Lord, on this court, the Honorable Single Judge has held that since your Lordship may kindly see he has quoted that, I am reading it on page 13, my Lord, internal page 13 of the judgment, my Lord.
Right.
Has your Lordship got it, my Lord?
So there's a modified punishment, is it?
Yes.
Reinstatement with cut and increment.
My Lord, it is not cut as reinstatement with all increment gone, my Lord. It is not a stoppage of increment. I'll come to that, my Lord. Let me first satisfy your Lordship that there was a violation of principle of natural justice, my Lord. Internal page 13, may I draw your Lordship's kind attention to paragraph 18 of the judgment, my Lord?
Yes.
My Lord, your Lordship, see, then he has taken out one line from here, one line from there, and has told that he has admitted, and therefore no opportunity be given to him because he is now properly defended, my Lord. Page 11, my Lord, paragraph 16, my Lord.
Yes.
That the proceeding, Honorable Judge has quoted, my Lord.
Yes.
Coming to the question of non-compliance with the principle of natural justice, in reply to the contentions raised that the petitioner was denied defense assistance by engaging one B.K. Mahanti, retired gazetted officer of the central government, Mr. G.A. Dora, learned senior counsel appearing for the bank, has referred to the proceeding of the inquiry officer held on 16/1/99, filed Annexure 6, which reads as follows. But then, your Lordship, the next page, my Lord. Same page, my Lord. CSO, charged officer, my Lord. EO 1, 2, 3, 4, my Lord. I have not completed inspection of documents. Mr. B.K. Mahanti, retired central government officer of village Kontapada, Nagpur district, Jagatsinghpur, will assist me as defense assistant. His consent letter is produced herewith. Then inquiry officer, the CS has not availed the opportunity given him for inspection of the documents. Then prosecuting officer says, I object to CBK Mahanti being defense assistant as he is neither a bank employee nor he is representing a trade union to which this CSO belongs. Sir, I couldn't find any suitable defense assistant other than CBK Mahanti, even though I made so many persons our and other banks. So he may be allowed to my defense assistant. This being a departmental inquiry and the instructions are reportedly well understood by the CSO, participation of an outsider in defense assistant is unwarranted. The CSO is not allowed to engage Sri Mahanti as defense assistant in his defense assistant, who has also not appeared today before me, though regular inquiry has to go ahead from today. Sir, I may be permitted to search another defense assistant, allowed another 7 days time for this purpose. The CSO should have arranged his assistant much before regular proceeding of inquiry. If allowed, this will result in undue delay. And on this ground, it was rejected. Now I draw your lordship's kind attention to the regulation governing the inquiry, my lord, which has been also reflected in the judgment, my lord. That is, your lordship, page 8, my lord, paragraph 11. May I draw your lordship's kind attention to page 8, paragraph 11, my lord?
Yes.
33, your lordship may kind of one paragraph above the last paragraph.
Yes, yes.
The inquiry under the regulation and the procedure with the expression of the final order may be delegated in case the person against to any officer who is in a grade higher than the such officer, and the case of an employee to any officer. For purpose of this inquiry, the officer employee may not engage a legal practitioner. The only bar was to engage a legal practitioner. But he says that since he is not an employee of the bank, so he will not be given an opportunity. And in spite of that, I tell that at least grant me 7 days time to find out an alternative. He says, no, it will be delayed. Very fast. Then, my lord, your lordship will kindly see paragraph 18.
Yes.
With regard to that is non-supply of documents and the proceeding is vacated, but he is good. I am submitting the list of documents and the list of witness in duplicate, my lord, presiding officer. CSP, please acknowledge the above. Yes, sir. Documents are readily available with me. CSO, you may go through the listed documents and obtain copies of relevant part if you need. You are required to submit certificates on the genuineness and authenticity of the same. I acknowledge receipt of 25 documents which have been detailed in the list of documents and certify that they are genuine and authentic. But this is says, but at first date the documents are supplied, and because of his certificate it is genuine, and he has got those documents. Then next page your lordship will kindly see. With regard to the allegation of the petitioner regarding non-exemption of witness, Mr. Dora has referred to the deposition in the department proceeding held on 10/2/99, wherein he has stated as follows: I want to produce myself as my defense witness, permitted. Further, if the petitioner is in exemption in the department held, has admitted as follows: I may not be made a delinquent for his lapses. Sir, on the whole, the lapses are minor in nature. I issued a register and the same was returned back undelivered with an endorsement. Addressee is not available. This led me to suspect the gold placed by Ramosau to be a non-existent person. Concluding the state that in account the 4 articles of charges, I have not made the bank sustaining a loss with any deliberate action, but I have made a sincere effort to safeguard the interest of the bank, accepting rupees 15, in regard to which I owe the responsibility. So he says that it is an admission. By the above consistent statement made by the petitioner in his deposition, he clearly admitted that he owed responsibility of any commissioner during his tenure as a matter.
Mr. Monty, by now he is superannuated.
I don't know, he is.
Yes, he is superannuated now, sir.
46.
He was 58 when the appeal was filed.
Brother? He was 46 in.
No. 58. When the appeal was filed, he was 58.
Eh? 58. Your Lordship may kindly see, cause title describes him in 2002 as 46 years.
Anyway, either way you see it, he's superannuated.
Brother, another 2 years is there.
No, just see the writ appeal, sir. Cause title, the writ appeal.
There is some mistake in the. I don't know exactly because in the writ petition, the cause title describes him as 46 years. Anyway, my lord, it is now a question of at least some amount of pension, my lord. Lord, taking out this cannot be admission, my lord, and this cannot be told that there is a bar. Lord, this is no appreciation, my lord, with respect. And where he says in the appeal that I am fortunate for this appeal, he says that he has accepted everything because he says that he is fortunate. Well, it is a language of the English language used by can it be interpreted in such
yes.
a manner?
Who's for the bank? Who's for the
I'm
bank?
there for the bank. Lord, one thing here is that there was no opportunity given to produce a defense assistant. The order sheet which he produced was 16,199. My learned senior read out. That's at page 11. 16,199. He said that I want to produce on B.K. Mahathi, retired central government officer of village so-and-so as my defense assistant. Prior to this, I won't take your lordship through the writ petition and all that. He had moved the disciplinary authority that, sir, he is not allowing me time. And the disciplinary authority turned down saying that, no, you can't allow an outsider. You can engage the bank's employee. Now, again, he praised that, kindly give me 7 days time. This was, I won't take your lordship through the disciplinary proceeding filed. It was shown to him that disciplinary authority turned down a request. So I won't allow one B.K. Mahathi who is an outsider. 16,199 is his request that was turned down. Now he came.
No, but he should.
10,299. So he had 21 days time. He had 21 days time to produce a defense assistant.
Where do you get that?
Page 13.
13.
Page 12, my learned senior read out. Page 11, the middle. The inquiry report has been quoted by the Honorable Single Judge. 16,199 at page 16, that is the inquiry held on 16,199. B.K. Mahathi was an outsider. In order to linger the proceedings, he wanted to induct that man. Now that was turned down by the disciplinary authority. So also the
No, the next hearing was 10-2.
Yes, next page, page 13.
Was the 10th February.
Yes, Lord.
So you say between 16 January and 10th February, he could have engaged somebody else.
Right. That's what the inquiry officer said.
But
The gravity of the misconduct
specifically, it has been declined, my lord. How could he engage?
No. On 16-1, it's declined. The next hearing is 10-2. Between these two dates, you could have engaged somebody, sir.
21 days.
There also he says that no time will be given for engagement of inquiry of.
No. Anyway, the inquiry is happening only on the next date, sir.
Huh?
So after the inquiry on 16 January,
Yes,
the next date was 10th February. Between these two dates, you could have engaged somebody else.
And the Honorable Single also referred to one Bansing's case in 97 Supreme Court, which has been quoted, that outsiders can't be allowed to participate in dismissal proceedings, which is amount to practice. That apart, the nutshell of charges are, which is quoted in the writ appeal, that he as a manager, he took spurious gold loans, mortgage, found it to be spurious, put it to auction. When he put it to auction, he had to write a sum about 4,000 something at all. But he did not disclose this in the branch manager's monthly statement. That is one charge. Next, what he did, he again put the same gold loan to another mortgage. Now, granted that loan to the gold appraiser's son. Granted him 10,000, took 5,000, adjusted that. And when he your lordship has already read that he issued register notice, there was no such noticing. There was no such addressing. And who has made the payment? It is some spurious person who made the payment. I won't take your lordship through the entire thing. Now, there is no vitiation of, no violation of natural justice. He was removed, and in appeal, it was modified to reduction of through increments. That's all. These are the grave charges which he has quoted at page of the writ appeal. Sir. Page 3, para 2. And he was a scale 1 officer, not a small man. He was a branch manager. Yes. He has submitted a false branch manager monthly certificate for the month of March 98 related to Dhekra Gramya Bank in the so and so, while the GL head office number so and so, whereas really balance of GL loan, agricultural loan so and so, and smaller amount tallied on 31/12/97 and 31/12/97. That is before. So there were so many irregularities which were committed by him, for which he was removed. Now the appellate author said that since reduce the punishment to
reinstatement without increment
in the same scale to the initial term, and he was denied the frontline position for the next 5 years.
Yes, Mr. Monty.
This is on the place, but at least when I reading of the statements and differs from persons to person. Prosecution would read it in some other manner, defense would read it in some other manner. But impartially stating, Lord, what is the loss, Lord? The loss is giving, my Lord, your lordship will kindly see. Lord, page 5.
Yes.
Thereby you fail to protect the interest of the bank causing of rupees 1157 in the above 5 accounts. In my defense, written statement of defense, I has basically said that it is respectfully submitted that Mr. Lakhinder Panda, the then field officer, tallied the small loan balance on December 1996 and March 1997 and had duly endorsed the same by putting his signature. I had the occasion to tally the small loan balance during September 1995 since the field officer was withdrawn from our branch from April 1997 to November 1997. From November onwards, the balancing of small loan account was done by Mr. P.K. Nandi, the present field officer, who tallied the small loan account as on December 1997, which has also been endorsed by him, and the same is available at small loan balance book. Basing upon the field officer report regarding tally and balance of small loan account, I report that matter to head office in manager's monthly certificate. Then, my lord, your lordship will see that second paragraph, last paragraph, it is humbly submitted here that jewelry loan was sanctioned to Ramosau for rupees 14,400 after receiving appraisal report from the bank gold appraiser Sri Bhaskar Chand Pusti, who had appraised the gold contents in the jewel ornament. It is indicated in the loan is that Ramosau was introduced to me by the bank gold appraiser Sri Bhaskar Chand Pusti. The loan was sanctioned to Ramosau to need his medical expenses for operation purpose. The jewelry praised by Samosa was later detected to contain lesser quantity of gold, and this was detected along with another jewel placed during 1996-94, the tenure of my predecessor. It would be desirable that Bahuti placed by Ramsu was not spurious as indicated in Sarah and contained lesser percentage of gold. Then what he did, the gold, he auctioned it, and 9,000 was recovered, and the gold appraiser took the responsibility of 5,000. So the bank's accounts was all right.
The question is,
Mr. Sawantrai wants to make it a very grave offense. It is a scam of few crores or few lakhs. Only for the 4,000-5,000 rupees.
No, but that's not the point. The amount is not the issue. It's the loss of confidence.
That's right, my lord. That is he go down on the ladder to the last stage of the increment. First increment also gone. Stoppage of increment will not mean that,
Yes.
Stoppage of increment is for future. You stop that increment.
All right.
one more thing, no? At page 14, my learned senior read out. I issued register. I may not be a delinquent for my lapses, sir. On the whole, the lapses are minor. That's what he says. Next, he says, I issued a register notice and the same returned back undelivered with an endorsement. Address is not available. This led me to suspect that the gold pledged by Ramasahu to be a non-existent person. Concluding, I state that the 4 articles of charge have been made by the bank sustaining loss. I'm not. The Honorable Single Judge has quoted from a counter affidavit, which is para 6, 7, and 8. In the down below, where I read, at page 14, he has gone through the Honorable Single Judge has gone through the entire brief, the entire district proceedings, and relevant page. So there is no violation of natural justice. He had been given opportunity. He defended himself. He said, I'm going to give my evidence. And now he can't turn around and say that it was unfair. The court didn't grant me 7 days time. That's all. But can it be said to be?
Orders reserved, sir.
Obligement.
Supplementary list item number 6.
May I please, Your Lordship? Your Lordship, I pray for 1 week time and instruction regarding the status of the case, Your Lordship, from my client. It's a WA of 2014, Your Lordship.
No, what's the delay? Let's see. There's a delay of 235 days in filing this appeal, which has not been properly explained. Consequently, the court is not inclined to condone the delay. The application for delay is dismissed. Consequently, the appeal is dismissed.
Supplementary list item number 7.
None appeals.
Supplementary list item number 8.
My lord, no instruction, my lord.
No instructions dismissed.
Item 9.
None appeals dismissed.
Supplementary list item number 10.
Item 9, my lord, no instruction.
No instructions. 10.
10, my lord, retopage is not maintainable.
Okay.
I think I took
Dismissed on the ground of maintainability. Right.
Supplementary list item number 11.
None appears dismissed on all prosecution.
Item number 12.
Dismissed for non-prosecution.
Item number 13.
Item 13.
Item number 13. There is no, I have no instruction because
All right.
now Bhushan Steel is no more existing. In Tata Steel has taken over, so that I have no instruction from Bhushan Steel.
No. In the meantime, I'm appearing along with him. In most of the cases, I'm appearing for the Tata Steel Bhushan Limited. In this case,
I have no instruction from Tata Power because Tata Power.
One minute.
Bhushan Power, I have filed the writ application, writ appeal, and the.
1 minute.
Bank
One
have
minute.
no instruction.
Whom are you for, Mr. Sarangi?
Mala, in this case, Tata Steel has been taken over this Bhushan Steel. Now Tata Steel is the owner. And in this case, the IBC code, under the IBC code, the NCLT passed the order. And in many cases, might not have passed this order that is covered under the Ghanshyam Mishra judgment. And that only that the order to be passed. That the demand
The
is.
limitation notice has to go. Because the appeal, as yet, limitation notice has not gone. Now, with regard to what is the status of the Tata or what is the status of Bhushan, I just submitted Bhushan is
Well, the IBC, kindly see this order. In every case, Mala passed this order.
So let us be clear. You are appearing for whom? It's not clear.
In this case, he has filed the appeal. But now
He has filed the appeal.
yes.
And he does not want to press it. Why are you harping?
Ultimately, it will affect me because in this case, I'm appealing for the Tata Steel. And today morning, I got the instruction. Today morning,
He's the counsel for the appellant, sir.
He's not, my lord, I should not say in this court. But my lord, today morning, I got the instruction that in this case, I should give this order to your lordship with regard to the IBC orders. Mine has passed in every cases. And Justice Sodangi has passed with regard to this Ghanshyam Mishra judgment. This case is covered by the Ghanshyam Mishra judgment. And basing on that judgment, my lord has passed this order. So for that, it is covered under that order.
What is the delay?
The demand is at 35 and 34.
You see, the delay is controlled. You see, it is pointed out that Mrs. Bhushan Steel Limited has been taken over by Tata Steel Limited. And there is a resolution plan approved by the National Company Law Tribunal, further confirmed by the Company Law Appellate Tribunal, in terms of which the dues of the opposite party respondent has to be dealt with. Full stop. In that view of the matter, the writ appeal is disposed of with the direction that, notwithstanding the judgment of the learned single judge, the dues owed by the appellant to opposite parties shall be considered in light of the judgment in Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Construction Company Limited, 2021 9 SEC 657, which explains the legal position in this regard. Right.
Supplementary list item number 14.
None appears to us.
Item 15.
None appears.
Item number 16.
Infractuous disposed of.
Item number 17.
None appears to us.
Item number 18.
My lord, in this case, my lord, that is against the order of arbitrator, my lord. I prefer that the appeal before the cooperative tribunal, my lord. That is
Not maintainable, sir. It's all 227. What's the delay?
there is some restoration due to non-deposit of a statutory.
Or the delay is controlled. The appeal is not maintainable as such, since it is against an order of the single judge in exercising jurisdiction under Article 227 of the Constitution.
My lord,
Consequently, leaving the appellant to seek other appropriate remedies. In accordance with law, the appeal is disposed of.
my lord, they may allow to move the the cooperative tribunal, my lord, with the deposit of cost, I have deposited all money. There is no outstanding, my lord. But I pray for closing of the proceedings. So for that's why, due to non-deposit of the statutory deposit, that is due to cause of accident. That is, I did not incline to restore my appeal there, TA number and 72 of 2000. So that's why I approached the Honorable Single Judge. Honorable Single Judge dismissed the case on due to such a medical certificate. Thereafter, I approached my lordship. There is a for my violation of the natural justice. I may be hard with this deposit, my lord, before the.
So this is a two proceedings, sir. No writ appeal is maintainable. Yes.
Item number 19.
None appeal is dismissed.
Item number 20.
None appeal is dismissed.
Item number 21.
21, no instruction.
No instructions dismissed.
Item number 22.
22 also no instruction.
No instructions dismissed.
Item number 23.
23, my lord, the sole appellant is dead.
All right.
I'll pray for 1 week time for substituting the
No,
appellant.
no. Defects have not been removed for more than 7 years, sir. Defects have not been removed for more than 7 years. The sole appellant is also dead. In the circumstances, the appeal is dismissed.
Item number 24. Item number 24.
My lord,
Dismissed for now.
This appeal has been filed challenging the order passed by the honorable single bench, not deciding the issue involved in the writ petition, that whether the registering authority has power to withhold the document or save its register. This is the only question is involved in this case. Kindly see the order on order dated 6/2/2015. May I please?
So how is the writ appeal maintainable?
This is writ of mandamus 226.
No. This is arising from a
Those suit, but
in a civil suit.
Yes, trial
Yes,
directed the sub-registrar to hand over the same, but sub-registrar has not hand over. Therefore, I filed this writ petition to give writ of mandamus directing the sub-registrar to return the document which has been executed and registered through court.
No, but there's a stamp case already initiated against you, sir.
Yes, I am relying on the decisions, reported decisions of this honorable court.
Yes. No, but why should we interfere with the single judge order? Why should we interfere with the single judge's order, sir?
The main issue is whether after registration of the document, registering authority has power to withhold the document or not. This is the point I have raised before the single bench, but honorable single bench.
No, since it is undervalued. No, it is undervalued, so he started a stamp case.
If it is
Yes.
undervalued and a impounding proceeding has been
Correct.
initiated, the sub-registrar will keep the original
Correct.
and he can get the certified copy, I
Correct.
think.
Correct.
But original will not be delivered to the executors unless the impounding fees is deficit
Yes,
stamp duty
deficit
is
stamp,
paid. That is the procedure.
stamp is to be recovered as revenue. Kindly see the.
No, but he can impound the. Suppose he's found it undervalued. Why should he allow you to collect the document? He can, even at that stage, stop it.
On page 7 of
Yes.
paragraph 7, page
Yes.
25. A cogent reading of section 52(1), section 62(2) of section 8A of the Indian Registration Act 1980, Orissa Amendment and Orissa and Rule 101(2), Orissa Registration Rule 1988 makes it amply clear that there is an obligation cast on the registering officer to make very endeavor to return the document promptly after the same is registered.
he cannot withhold any document after the same is registered for any other purpose.
Yes.
If upon inspection or otherwise, it is found that the fee payable under the Registration Act in relation to any document which is already registered has not been paid or has been paid insufficiently, such fee may be recovered from the person who presented such document for registration as an area of land revenue. My humble submission before your Lordship that if any area that should be recovered as land revenue, but once registration is made, that should be handed over to the person.
All right. The challenge in the present writ appeal is to an order dated 6th February 2015 passed by the learned single judge dismissing the appellant's writ petition civil 19077 of 2008. Paragraph. The above writ petition had been filed by the present appellant for a direction to the district sub-registrar Cuttack to comply with an order dated 3rd November 2008 passed by the civil judge, senior division, 1st court Cuttack in TS number 247 of 1998 to deliver the registered sale deed bracket RSD bracket to the vendee on proper acknowledgement. Paragraph. As it transpired, the RSD was undervalued and proceed was accordingly initiated against the petitioner under sections 27 and 47 capital A of the Indian Stamp Act. Paragraph. The learned single judge has, while relegating the appellant to the proceedings in stamp case number 789 of 2008, declined to grant the relief as prayed for. Paragraph. This court has heard submissions of learned counsel to the parties. Paragraph. Counsel to petitioner relies on the decision of this court in Kunkumina versus sub-registrar to urge that a document cannot be withheld. A stamped document cannot be withheld after it is registered for any purpose. The remedy for short payment of stamp duty is only that it could be recovered from the person who purchased document for registration. Paragraph. The court is not persuaded that the appellant has been able to overcome the issue pointed out by the learned single judge, namely that the undervaluation of the RSD has resulted in a stamp case number 789 of 2008. Which has to be adjudicated before the appellant can be permitted to collect the RSD. Consequently, the court is unable to find any error having been committed by the learned single judge in disposing of the writ petition filed by the present appellant by the impugned order dated 6th February 2015. The appeal is accordingly dismissed.
Supplementary list item 25.
No instructions, my
No
lord.
instructions.
My lord, sir, my appearance for a respondent may be noted.
All right.
Supplementary list item 26.
May I please, your lordship? It's in this tab. Kapil, I'm challenging the order under Annexure 1, my lords. The case of assessment of under the Electricity Act, my lord, assessment order, was after the provisional assessment order was made, petitioner submitted a representation, but instead of considering that representation as per the act, the assessing officer issued the notice of disconnection petition, my lords. But in the input, the honorable single judge has directed to take a decision upon the representation. However, the disconnection notices which have been issued, they need to be quashed, my lords. Otherwise, Before taking any discussion, they will.
This is a matter of 2015. What
My-
has happened in the last 7 years?
Well, it's not because there is an interim order, no decision upon the representation has been taken till date, and no recovery has been made. My lord.
What is that? Nothing,
Up to
nothing's
11,
happening to you then.
interim order or contract status order up to 11/5/2015. Thereafter not having extended.
My lords, but my instruction is that no decision has been taken upon the representation, my lords. My lords,
Don't worry, you're not losing your electricity. Nothing's happening to you.
my lords,
The only relief that the appellant is praying for at this stage is that the appellant's representation should be against the relief by the respondent should be considered in a time-bound manner. Given the limited nature of the relief being sought, it is directed that the appellant's representation dated 24th September 2014, bracket annexure 3, be considered by the respondent.
If any cause of a subsists, if any cause of a still subsists,
If any cause of action still subsists within a period of 4 weeks and in any event not later than 26th October 2022. The address and the appellant be communicated the said decision within a week thereafter. Paragraph contrary, the appellant states that there has been no disconnection of electricity of the appellant in the meanwhile. Consequently, there is no need to pass any interim orders in that regard at this stage. The appeal is disposed of.
my name may be recorded. Respondent.
All right.
Supplementary list item 27.
Your Lordship, matter may be taken over 1 week after due to non-available document the file. The matter may be taken over 1 week after, Your Lordship.
What's the matter about, sir? Requisites have also not been filed.
Your Lordship.
You have not even filed requisites, sir, for the last 7 years.
Maybe Your Lordship may be taken over 1 week after, so that I will comply the court order.
No, not at this stage, sir. Notice was issued in the petition way back on 2nd January 2017. Even the requisites have not been filed since then. Consequently, this court is not inclined to give any further indulgence to the petitioner.
Your Lordship may be
Number
taken
921 of 2016 is dismissed. Consequently, the appeal is dismissed.
Supplementary list item 28.
Well, this is a matter regarding appointment of Anganwadi worker. A small matter, but this matter, my lord, involves the question of fraud. How fraud has been committed with the help of executives at the level of, my lord, appointment. That I will substantiate before your lordship, my lord.
Who's for the selected candidate? There must be one selected candidate.
Yes, I'm the appellant, and somebody is continuing by doing fraud, my lord.
No, that's right. That's opposite party in the respond number 5.
My lord.
Who's appearing for respond number 5?
The government.
No. Mr. Ranjit Manti's name is shown as for respond number 5.
My lord.
Where is he?
My lord, 17/4/2018, there is an order of this honorable court. CDPO to be present on such and such date with all records, because I can, under Act, I have submitted all the records showing, my lord, how this in every layer of the selection, how they have committed fraud, and they are supporting this appellant.
As the impugned order, let may see the CDPO was called. The single judge, the honorable single judge, has perused records and has found that the village that was written, that Millards, admittedly, she does not belong to that village. There is the document that was presented before the court in the writ petition has another place written in parenthesis under the name of the village that was written.
No. She's saying that it's the respond number 5 who has committed that fraud.
Yes.
Millards, but the original record, Millards, he has seen the honorable single.
You said none appears for respond number 5 today.
May I, Millards, read the
counsel for the? You better produce the record then. Yes, counsel for the appellant states that he will. Respondent number 1 state offers to produce the record, original records on the next date. Original relevant record on the next date. 12th January.
Item 29.
May I please, Your Lordship? This is against the order of the Honorable Single Judge, reversing an order of the Consultation Commissioner and Appellate Authority.
Yes.
Well, the land was initially recorded in my name on the basis of a will. Then almost after 20 years, in a 37 proceeding initiated by this opposite party number 4, respondent number 4, the matter was remanded. Then it was held that the will which was the basis was not produced at that time at the stage of 15-1. So the consolidation officer rejected, set aside my recording. Then for an appeal. Appellate court found as a matter of fact that it was produced and it was acted upon and directed recording of my name. Then commissioner confirmed that order. The Honorable Single Judge set aside both the appellate order and the commissioner's order on the ground that the tests for validity of the genuineness of a will, that is its execution and attestation, is not duly proved, so set aside. Whereas the deputy director, while exercising appellate jurisdiction, says that it is proved and the witnesses well proved it, and the consultation officer, because the witnesses could not say the plot number, khata number, he disbelieved.
Who's appearing for respondent number 4?
Mr. Meher was appearing.
Well, I am opposite party number.
Yes.
Millard. Millard, only submit. Please to find the annexure number 2, my lord, the order of the consolidation officer, Binka. The will itself has been produced after the remand division. Now, it is an afterthought, but specific. The consolidation officer specifically ordered. It is an afterthought. The will itself is suspicious one. So, the Bhumi Sita, who is not natural born daughter, she is a cousin daughter. That the opposite party number 4, who is a respondent, Miller, the mother of the respondent number 4, is a natural born daughter of the late Rusi, and she has in actual physical possession over the case land since their forefathers. It's very clear, Miller. Please to find annexure 2 at page.
No, what's the relationship between the original writ petitioner and respondent number 4?
Miller.
No. What is the relationship between the petitioner and respondent number 4?
They are two sisters. Cousin sisters. Miller.
Cousin sisters.
Cousin sisters.
And now the writ petitioner is substituted by her son, is it?
Oh, Miller. Substituted. She has already died. Is substituted by Anand Sahu. The respondent number 4. Anand Sahu. So, it's nothing but a afterthought. And it is totally the will itself is suspicious, and rightly the Honorable Single Judge has passed the order.
All right.
Rusi Sahu was the original owner. One is the original daughter, another is the
cousin.
Her cousin. But cousin is with a will. And the Honorable Single Judge has extensively discussed the materials on record and came to a conclusion that the impugned will is shrouded with suspicious circumstances and not a genuine. And there is no problem. That is why he has recalled the order of all the lower courts below, the authority, appellate authority, then revisional authority. So it is a finding of fact that the will is not genuine. Therefore, he has not given any relief to the appellant before your lordship.
Yes, please.
Page 25 of the writ petition, the deputy director at the first instance dealt with that will in appellate jurisdiction. Page 25 of the writ petition. Internal page 5 of that order.
Internal page 5.
Internal page 5 of deputy director's order and running page 25 of the
25
of the writ petition.
Yes, yes.
Shall I place, my lord?
Yes, please.
On perusal of the documents, I found the second paragraph, my lord.
Yes.
On perusal of the documents, I found that in order to determine the genuineness of the will, the consolidation officer has examined both the witnesses in whose presence has been executed. Both of them adduced in their statement that the will has been written by one advocate, Sri so-and-so, in their presence. It was ascribed on a stamp paper which had been purchased by Rushi. Both of them expressed that it was written in their presence in Rampur and was explained to them. They further have stated that by the time of execution of the will, Rushi was physically and mentally sound. Rushi has expressed his desire in the will to give the land measuring so-and-so under khata number so-and-so village so-and-so to Bhumisuta as a token of her service to them in their old age, which is to be operated after. The consolidation officer has done the right thing by examining the witnesses, but he has gone beyond the limit, asking about the plot number and khata number, etc. at the time of execution of the deed, which is nothing but extrajudicial. It is but natural on the part of semi-literate and rustic villagers to answer all these particulars of the land. In this case, the primary duty of the consolidation officer was to ascertain from the language of the testator that what were his intention, that is to construe the will. He should have gone through the will and should have considered the position of the testator, his family relationship, etc. In order to determine further the genuineness of the will, he should have asked the witness whether the testator at the time of executing the will was physically and mentally sound. On perusal of the will, one can easily read the wishes of Rushi, who had expressed his desire to give the suit land as a token of service to Bhumisuta in her old age. The relationship of Rushi and Bhumisuta and the surrounding circumstances under which the will was executed should also be well considered. After giving in marriage to Tulsa, his only daughter at a distant village, there was none to look after the old Rushi and his wife. That is why he gave shelter to Bhumisuta, the appellant, at his house, who looked after them staying in the village, and as a token of her service to them, he had executed the will which is to be operative after his death. Bhumisuta has also occupied the suit land after death of Rushi. She had filed objection under section 15(1) of the Act, and the ROR has rightly been issued in her name. Thus, there is nothing to doubt regarding genuineness of the will after examining the witnesses, the language and the wishes expressed by the testator in the will. Moreover, the appellant's plea of perpetuating the adverse position of children cannot also be ignored. The long silence of Padma and the respondent also clearly indicates that the suit land has been in cultivating possession of the appellant on the strength of the will within knowledge for last 20 years. In view of the above circumstances, in order. So that is how the deputy director believed the genuineness of the will, and that was confirmed by the commissioner. The consolidation officer only disbelieved because the witnesses could not say the plot number and khata number, which the deputy director says it is not possible to recall those things, and those are also extraneous to the consideration of genuineness. Whereas the will recites itself that it indicated the intention of the testator.
But it did not see the light of the day.
Yes, it was at the 15(1) stage I had brought it. The deputy director says, my lord, your lordship may kindly see. Page 3 of that order. Page 22, running page 22. The deputy director has exhaustively dealt with those things. Last paragraph, in the year 1979, consolidation officer took place in this area and land register was prepared for the entire land in the name of Rushi Sahu. Rushi died in the year 84. The village-wise objection register reveals that after death of Rushi, Bhumi Sutta and the strength of the will filed an objection before the consolidation officer to get the land recorded so bequeathed. Accordingly, ROR issued in course of consolidation officer in favor of Bhumi Sutta. And long after this, in 2003, this Tulsa moved the commissioner under section 37 and a remand was made, and thereafter all these disputes.
Yes.
84, it was recorded in mine.
My lord.
Yes.
When there was a remand of revision, then only this document was produced.
Correct, correct.
First initiation, it was not produced. Therefore, it is suspicious, my lord.
Right.
My humble submission.
Yes. Yes, so we're not inclined. Sir. We'll pass the detailed order. Right. The writ appeal is dismissed. Yes.
Supplementary list item number 30.
None appears dismissed in opposition.
Item 31.
None appears dismissed in opposition.
Item number 32.
This is an appeal. My lord, I am a selected candidate. I have selected for the post of Anganwadi worker, my lord. And being agreed by my selection, my lord, the respondent 4 has preferred the appeal. Appeal has dismissed by the appellate authority. Against whom, my lord, challenge this writ application. The honorable single judge, consider your lordship page 33. The impugned order page 33, my lord. Running page 33, my lord.
Yes.
May I read, my lord?
Yes.
In that view of the matter and keeping in view of the government guideline and taking into consideration the circular which is not brought to the notice of the learned single judge of this court, I hold the petition has been denied opportunity of presenting her case before the selection court, particularly when she has physically not in a position to appear before the selection court. Accordingly, I set aside the recruitment process, engagement of Anganwadikar for Tolasai Anganwadi Center. Your lordship, the circular which has relied by the honorable single judge, there is no existence. I have annexed, my lord, that circular annexer 5, page 28, my lord. Issued by District Social Welfare Officer, my lord. Dated 25/6/2007, my lord. Your lordship.
Yes.
Similarly, candidate failed to appear before the CDPO on fixed date of verification of certificate. Her candidature shall not be rejected and she should be given opportunity for verification. May I relevant to referring the letter, your lordship reference. A reference letter number 145 dated 2/5/2007, my lord. Issued by the Commission Cum Secretary W and CD Department, my lord. That letter number 125 and 257, I have also annexed my appeal, my lord. Your lordship can glance. Annexer 3, page 20, my lord. There is no such a clarification, my lord. This is a manufactured one, my lord, letter. Your lordship, I have annexed page 20, annexer 3. This is a letter issued by Commission Cum Secretary, my lord. Letter number 145 dated 2/5/2000. Entire no here, my lord. Such a relaxation has been given, my lord. I have also, my lord, this book, my lord, the 2/5/2007 circular is there, my lord. There is no relaxation there. The letter which has no existence at all, on basis of which the writ application entire process of selection has been set aside, my lord. I am a selected candidate. At present, I am also continuing.
There was a status quo here.
Yes, my lord.
Yes. You've been continuing for how many years now?
My lord, I have continuing from 31/3/2010, my lord.
12 years. Yes, please.
Lordship, I am in opposite of 4, lordship.
Correct.
Then single judge lordship make direction for fresh selection, lordship. For fresh selection, lordship.
No, but why should
And
there be
due
a
to
fresh
cesarean,
selection, sir?
on the date of verification of document, lordship, I was not present there. Due to cesarean, I was not present on the verification of document, Lordship.
That's all right, sir.
So opportunity are given to me to submit documents for present before the verification committee, Lordship.
Your Lordship, may kindly annex or page 26, the finding of the appellate authority, my Lord. Paragraph 4, my Lord.
Yes.
Page 26. It is also contended by the learned counsel for the appellant that the appellant was present on 30/3/2010 and the application and document were duly verified by the CDPO and give endorsement thereon to that those are verified. During course of hearing, the learned counsel stated that the appellant was absent, my Lord.
The contradiction.
My Lord. On the date of verification, she was not present. As such, my Lord, she has not been shown in consideration. I have selected, my Lord.
No, she says she was not in a position to appear physically.
No, but there is no relaxation clause, my Lord. I have also cited a decision of this honorable court, my Lord. The honorable single judge has quoted, my Lord. Quoted that judgment. He reported in 2014 2/127, my Lord. Srimati Kunmuni Malik versus Collector Puri, my Lord. Enter quoted, my Lord. There is no relaxation clause, my Lord. The guideline is specific, not relaxation clause, my Lord.
How many sums, Lordship?
This judgment, my Lord, well, my Lord, the selection committee has no discretion to defer the matter, my Lord.
Please, ma'am. That's correct.
There is no provision for entertaining application at the behest of a candidate of defer the date of verification of document on the ground of illness. My Lord, this judgment has been, Lord, reported.
Where is it? I mean, has it been referred to in this?
Yes, may see page 30, the last paragraph. Srimati Kunimani Malik versus Collector.
Right.
Apart from this, there is no existence letter. This letter has been manufactured by the district office only to favor, my Lord. There is no such existence letter, my Lord. 25/6/2007. Referring the letter dated 2/5/2007, my Lord. Your Lordship can. Annexure 5, there is no existence, my Lord. Referring letter dated letter number 145 dated 2/5/2007, my Lord.
Where is the finding that there is no such letter?
My Lord? Yes, my Lord.
No. Where do you get it that there is no such letter?
My appeal, my Lord.
No. You're saying page 28, this reference.
Yes, my Lord.
Letter number 145
dated 2/5/2007, Commission cum Secretary to Government W and CD Department, my Lord. Yes, my Lord. I have annexed that letter number 145 dated 2/5/2007, my Lord. Annexure 3, my Lord. Your Lordship also, madam, book is there, my Lord.
So it's merely enclosing revised guidelines.
Lord's book is there. There is no provision. That provision is not there. This is amended surplus, my Lord. There is no provision also relaxation, my Lord. I have given the book, my Lord, amended.
Yes.
2/5/2007, letter number 145, my Lord.
All right. You see, this appeal is directed against the judgment dated 9th February 2015 passed by the judge, allowing writ petition civil 16690 of 2011 filed by respondent 4 and setting aside the selection of the present appellant as Anganwadi worker bracket AWW for the Teli Sahi Anganwadi Center bracket AWC under ward number 3 Bhanjanagar NAC and directing the authorities to make a fresh selection in accordance with law after giving an opportunity to all the candidates to present their case. Paragraph. While directing notice to issue the present writ appeal on 11th February to May 2015. Sorry, on 27th March 2015. This court directed status quo to be maintained. That interim order is continued. So in effect, therefore, the appellant has continued as AWW at the aforementioned AWC in the meanwhile. Paragraph. The background facts are that an advertisement was issued for appointment of AWW at the aforementioned center on 15th March 2010. So among the applicants were the present appellant and respondent 4. Full stop. The date for scrutiny of the application was fixed of 30th March 2010. Full stop. Admittedly, on the date of scrutiny, respondent 4 was not present with the relevant documents. Full stop. The appellant was selected and appointed as AWW. Paragraph. Agreed with the selection of the appellant, respondent 4 preferred MC Appeal number 53 of 2010 before the Additional District Magistrate bracket ADM bracket Ganjam. The appeal was dismissed by an order dated 28 January 2011 of the ADM. Full stop. The said order was then challenged before this court by respondent 4 by filing writ petition civil 16699 of 2011. Paragraph. There are single judge as in the impugned order. Take note of the decision of this court in Srimati Kunimani Malik versus Collector Puri 2014 2 OLR 177, which clearly states that there can be no relaxation in the time limits in terms of the guidelines for appointment of AWWs. Full stop. Nevertheless, only on the ground that respondent 4 was more meritorious than other candidates, and that there was a circular which stated that in case of genuine difficulty, the CDPO selection committee should grant time to the candidates to produce the original certificates. The learned single judge has passed the impugned order, setting aside the entire process. Paragraph. This court has heard submissions will and counsel of the parties. Full stop. At the outset, it must be noted that the decision in Srimati Kunimani Malik versus Collector Puri Supra still holds the field. Full stop. It reaffirms that the administrative guidelines issued is binding on the selection committee. Full stop. Neither the selection committee nor the CDPO has been vested with any discretionary power to relax the norms. Full stop. There are definite time limits for inviting applications and verification of documents. Full stop. If a candidate, for any reason, which could include ill health, is unable to be present, comma, there is no discretion left in the selection committee to extend the time for doing so. Paragraph. The letter dated 25th June 2007, purportedly written by the District Social Welfare Officer Chhatrapur to all the CDPOs, that a candidate who fails to appear before the CDPO on the fixed date for verification of certificates should be given an opportunity on the next suitable date does not appear to be based on any of the guidelines issued. Full stop. That document refers to a letter L number 145 dated 2/5/2007. Full stop. That letter, comma, which is enclosed as Annexure 3 to the writ appeal, comma, merely encloses the revised guidelines for selection of Anganwadi workers. Full stop. It nowhere grants any discretion in a selection committee or the CDPO to relax the time limits for production of documents. Full stop. In the circumstances, there was no justification for extension of any time limit to the respondent before, who was not present admittedly on the relevant date, comma, to be given one more opportunity to produce original certificates for verification. Full stop. Consequently, this court finds no justification for the learned single judge to have set aside the entire selection and directed authorities to conduct it afresh. Full stop. The impugned order of the learned single judge is accordingly set aside. The writ appeal is allowed, but in the circumstances with no orders to cause.
Oblique. Supplementary list item number 33.
Humbly submit. The petition in pursuant to the advertisement by the annexure number 3 in WPC number Mellot 25009 of 2011, the CDPO Palangir terminated the petitioner with a condition that the petitioner has not fulfilled 2 years diploma course for the post of the Shiksha Sahayak in Balangir, in the district of Balangir, and therefore he terminated only on Mellot 5/9/2011 for the post of the Shiksha Sahayak. The Mellot, then the petitioner filed a writ petition. The Honorable Single Judge also dismissed and did not consider well. Please to find Mellot annexure 3 of the writ petition at page 13 Mellot. Very clear that
there must be an upper age limit, sir. Now,
Mellot,
there is an upper age limit for these posts. Shiksha Sahayak.
Shiksha Sahayak.
What is the upper age limit?
Age limit 22 Mellot.
Upper age limit. Upper age.
What
45.
45. So, Mellot, my humbly submit, the annexure 3 very clear in the middle part at page 13 Mellot, even if he has not completed 2 years diploma, but it's because he has already engaged thereon, but during the pendency of the service Mellot, he has to give an undertaking to fulfill the 1 year. It is the very, because he is a as per annexure 1, my lord, is a disabled in 40% disabled person. Their advertisement is very clear.
No, but you have to complete your diploma, sir. 2-year diploma you have to complete.
Yes.
Only then you can be employed.
No, my lord, annexure 3, the middle part very clear.
Sir, what is annexure 3? What is annexure 3?
Disabled person, there it is ODI advertisement, my lord.
No, annexure 3 is some
page 13, my lord. Please to say. Jodi Samprukt, it is in Oria, my lord. Jodi Samprukt Sikha Jilla Unit Avasya Sankhya Tafsil Upajukta Jati, Janajati or Saririko, Okemo Talika Prathi Nomilandi, Nomilandi, Bharat Sorgano Sikha, the Jogya Sampakita, they had the Nidista Adesa Prakta, have a pressure on a Pishoku, which are never Nijukti. Tapre, then and there, my lord, again, another sentence. Samasta Onajati. এই অনতালিম প্রার্থী মানে নিয়োজন হেবার 5 বর্ষ মধ্যে নিজ খরচরে তালিম প্রাপ্ত হেবে বলি এক অন্ডারটেকিং দেবে দ্যাট দিস উইল গিভ দ্য অন্ডারটেকিং উইদিন দি বিকজ হি ইজ অলরেডি এনগেজড দি সিডিপিও sorry the district project officer has already engaged after verifying all the documents, my lord, humbly submit, and he found then and there 2 years of diploma course. Therefore, he miserably failed to understand the advertisement as prescribed by the government. The very clear line. And because he is a disabled person, 40% disabled person, that there is that he has got the chance and scope as per the advertisement value. And that post is vacant now also.
No, 40% disability is what? Visual impairment?
I my lord.
What are your instructions?
Page 13, that is in Odia. The condition is that, my Lord Justice Das, যুক্ত 2 কড়া বাণিজ্য কিংবা উপযুক্ত অত্র ঘোষিত ততুল্য পরীক্ষার পাস যোগ্যতা সহিত ওড়িয়া মাত্র সপ্তম পাস থাই রিহ্যাবিলিটেশন কাউন্সিল অফ ইন্ডিয়া আরসিআই দ্বারা স্বীকৃতিপ্রাপ্ত 2 বর্ষীয় ডিপ্লোমা 2 years diploma in education, special education. That he has not that special 2 year diploma in education.
No, he says the clause permits an in-service person to complete it. They are giving an
first is the eligibility criteria.
No.
In respect of physical handicap persons. Subsequently, in respect of SC and ST persons, those who are not trained, they will that is a clause that they will complete their training within 5 years. In respect of SC and ST, but so far as physical handicap persons, they have that is the minimum eligibility criteria. They must have 2 years diploma in education, special education. That he has 1 year special education.
That relation is not for physically handicapped.
Not that. Sadharan that he is reading.
Middle page, my lord, very clear. My middle page.
ସମସ୍ତ ଅଣତାଲିମ ପ୍ରାପ୍ତ ପ୍ରାର୍ଥୀ ନିୟୋଜିତ ହେବାର 5 ବର୍ଷ ମଧ୍ୟରେ ନିଜ ଖର୍ଚ୍ଚରେ ତାଲିମ ପ୍ରାପ୍ତ ହେବ that is in respect of SC and ST candidates who are untrained persons.
I see.
So my humble submission, my lord, it is.
And you will also see the order of the single judge.
No, he notes the same thing, that he does not have the diploma.
Yes,
right. Yes, please. What do you say?
Another clause is that my learned friend is saying that you will also again see that if candidates of that category are not available, that is the clause. যদি সম্পৃক্ত ইউনিটর আবশ্যক সংখ্যক তপশিলীভূত জাতি জনজাতি ও শারীরিক অক্ষমতা ন মিলନ୍ତି, if not available, then they will be considered. Here they are available. You will also have seen that honorable single judge order.
Yes, what do you say, please?
Post is now also the post is vacant, my lord. As per the instruction of petition, appellant, the post is vacant, my lord. So
If people are available, then his post is vacant.
a disabled person, my lord.
I cannot say.
He is searching for 11 years. Years to then.
You want to find out if there's any vacancy?
Yes, ma'am.
Well,
As a physical handicap, I'll take instruction with the
handicap.
post.
All right. Counsel for the appellant insists that there are still vacancies available which can be filled up, against which the appellant can be offered appointment. Counsel for the state seeks time for instructions. 19th October.
Supplementary list item number 34.
Obliged.
34.
None appears dismissal, not prosecution.
Item number 35.
May I please, Your Lordship, in this matter, the learned single judge had passed order for obtaining back wages according to section 33, subclause C, subclause.
So this is not maintainable, sir. Not maintainable.
That is what I'm praying. That now they are pursuing as per the honorable single judge's order. In that light, I seek disposal.
All right. See, apart from the fact that the writ appeal is not maintainable, counsel for the appellant states that the order of the learned single judge is being implemented, and he does not wish to press this appeal. The appeal is accordingly disposed of.
Obliged, my lord.
Item number 36.
None appears dismissal, not prosecution.
Item 37.
None appears dismissal, not prosecution.
Item number 38.
May I please? My lord, 38.
Item 38.
That is, my lord, the defects pointed out.
How much is the delay, sir?
Delay 10 days, my lord. The Honorable Supreme Court says that it applies Annexure 5, your lordship, may kindly see. Annexure 5.
In this case, my lord, subject to lordship's kind permission.
First, whether we the appeal at all, let us see, sir. Let us see whether we want to admit the appeal. You are for the other side, correct?
No, my lord, I am also for the appellants.
Let us see if you want to admit the appeal. Delay is 110 days. It's not properly explained. And defects are also not being cured.
Page 129. Since against the impugned order, writ appeal under the Orissa High Court rules is provided, therefore the special petition is disposed of with the liberty to the petitioners to.
All right. Why haven't you cured the defects, sir?
Defects, my lord, 2 days because point of law.
What is the matter? Let's see the impugned order. What is the impugned order?
Impugned order, my lord. The Honorable Single Judge directed that IPR is applicable to the hotel industry as they're coming under the policy. And our stand, my lord, that the OERC has fixed a tariff, and in the tariff, objection were invited. It was heard and it was decided tariff was upheld. And the tariff, so far the petitioner is concerned, he claims under the IPR that middle.
No, but you are also bound by whatever is the industrial policy resolution, sir.
No, my lord. Our stand is that we are not bound by the policy because the government is not coming forward to deposit the said amount because incentive is given by the government, not by the electricity authorities. And the government in this counter says that we have no money.
No.
And they have supported.
Even Electricity Commission is also bound by the government policy only, sir. In fact, there is a provision in the act that you are bound by the policy of the government. If you look at the Electricity Act.
So here also the OERC order is also under challenge.
So ERC order indirectly, my lord, my lord, honorable single judge, as also there is a specific that 111 is the my lord for appeal, to file appeal, because already tariff order has been fixed by the honorable.
That's okay. Now the whole writ petition has been dealt with on merits in detail. It's all right. We're not going in the maintainability of the writ petition.
Our submission is that the learned single judge has decided the matter on section 108 of the Electricity Act without reading or without taking into consideration section 65 of the said Act. It cannot be read isolatedly. Both the sections are read conjointly. And the Honorable Commission says that if anybody want to extend any benefit, he should deposit the said amount ahead. And that is and they have not preferred any appeal. The hoteliers, they are before the OARC, and this petitioner was not a party there. And neither of the hoteliers are preferred any appeal before the tribunal. So appeal provision is there, my lord. If they have any grievance, they should approach the tribunal.
And similar writ petition also be dismissed.
Either you say or I say.
No, I ask it just to.
My lord, I'm sorry with the interruption.
Yes. Now, what was to happen in terms of the impugned order? The additional tariff was quashed, is it? The bills were quashed. What has happened, sir? What is the relief granted by the learned single judge?
Relief granted, sir, my lord. To consider them under the that bill that we raised, that is quashed.
Annexure 1 was quashed.
Yes. We have read under the PR.
Connection notice. That industrial policy resolution concession must be only for a limited period, sir.
Yes. That is, they have claimed that we are entitled for the relief.
No, what has happened to the subsequent period? This is a bill raised for a particular period, right?
Yes, that is under the 2001 policy.
No.
96 policy.
This bill is for which month? The bill is for which period?
Chief. That is annexure 1 to the application. We are at page 58.
No, this is for the months of May and June 2007, sir.
Yes.
We are in 22. What has happened after that?
My lord, I'll take instruction if lordship and grant me at least some time.
No.
Because it is a transfer brief after Mr. Naik.
No, and this has never come up, sir, even once. Even once it has not come up. There's no notice issued in the writ appeal.
Yes. Therefore, may I pray, my lord, only on Monday, I'll take instruction in the meantime.
Defects, what are the defects 6, 8, and 9?
Defect that the status of the party not given mention, and the miscase, the point of law not given, and page 60, 62, and 61 are not neat copy. 60, 61, 62.
Defects be removed within a week at the request of counsel for the appellant. who needs time for instructions on the present status list on 20th October.
Supplementary list item 39.
No instruction.
No instructions dismissed.
Item 40. Supplementary item number 40.
None appears. Dismissal now was.
Item 41.
None appears. Dismissal now was.
42.
All right.
Item 42.
None appears. Dismissal now was.
Item number 43.
None appears.
What is the lordship I am appearing and Mr. Ponda? 43.
Item 43.
I am appearing for the opposite party.
All right.
43 lordship state I come to page 22. The petitioner is continuing as an Anganwadi worker since 2008 lordship. That is at page 22. I have given the order of appointment. Page 22 lordship kindly 1778 at serial number 11 lordship is continuing since 2008 lordship, and lordship kindly then come to order of the appellate authority, that is just running to 36 lordship. Lack of competence because under the guidelines lordship, the ADM is the appellate authority, but order has been by the sub-collector. But lordship kindly the peculiar to this order, the honorable single judge, while justifying the competency of the sub-collector, has allowed writ application, and that has been stated by this honorable court lordship in writ appeal. For a moment, lordship kindly see only two provisions of law, that is page 30 and 70 lordship. Page 30 lordship, that is Anganwadi guidelines. Lordship, that is ADM is the appellate authority. And lordship can say page 70, the notification itself also lordship 2010 notification. The state government declared ADM as the appellate authority. But the order has been passed by the sub-collector, which has been justified by honorable single judge at para, that is first para 39, para second 39 lordship, page 39.
Where are you referring to, sir?
So, lordship.
Where are you referring?
Lordship, page 30, lordship, page 30. ADM is the appellate authority, lordship, that is there.
All right.
Then page 7, lordship, the notification I am relying, lordship, page 70, 70, lordship also. The government notification. Since 2010, ADM is the appellate authority. But sub-collector, while cracking about the appeal, is denying his competency, lordship. He is saying, no, the lack of competence I will not allow the appeal, lordship. But honorable single judge, justifying the order of the Miller, he justifying the order of the power of the sub-collector as a competent authority, as that was earlier sub-collector was the appellate authority in old guideline, and that's relying upon the old guideline, the order has been passed, lordship. But I am supplied the new guideline, lordship, with notification. Since 2010, ADM is the appellate authority, lordship. 10/3/2010, perhaps, lordship. Page 39, lordship, last paragraph, lordship. It is settled, lordship, in two paragraphs. Thus, the appellate authority has come to conclude that the selection committee has followed the procedure as laid down under the guidelines. Ultimately, the sub-collector has passed the order regarding lack of his competency to cancel the appointment order of the private opposite party, and his competency has not been disclosed by the sub-collector in the imposed order. It is settled position of law that whenever power has been conferred upon any authority to adjudicate upon the issue, the authority will exercise power with its entire competency. Here, in this case, the sub-collector has been conferred power of the appellate authority in the guideline dated 2/5/2007, which is resolution issued by the Women and Child Welfare Department, Government of Odisha. So this is the notification of 2010 has not taken into consideration. Now, my lord, that after 2010, ADM is the appellate, but order has been passed in 2015, lordship.
Who is appearing for the other side? Or notice is not gone? No, notice is gone.
Notice is gone. Since 2008, I am continuing, lordship, more than 15 years.
All right. Is it the present appeal is directed against an order dated 20th April 2015 passed by the learned single judge. disposing of writ petition civil 716 of 2011, filed by respondent before hearing,
Lordship.
challenging the selection of the present appellant as Anganwadi worker, bracket AWW, in the Mathikai Anganwadi Center, bracket AWC. Paragraph. Agreed by the selection of the present appellant, the respondent before, on the ground of non-calculation of marks secured by respondent before in the compartmental examination, he filed an appeal before the sub-collector.
At that point of time, sub-collector was the appellate authority.
No, he says at that point of time, it was not.
In 2008, appeal was filed in 2008.
No, but by the time appeal was decided, he was not the.
Yes, at that point of time, he was not the. But when the appeal was filed in 2000.
Filing is one thing, sir. The procedural requirement is that at the time of deciding the.
At the time of deciding, he was not. Yes.
He was not the authority. Sub-collector Bir Maharajpur, by filing appeal number ICDS appeal case number 1 of 2008, paragraph. By an order dated 10 December 2010, the sub-collector came to the conclusion that the procedure adopted by the selection board for computing the matriculation marks of the respondent before for the purposes of selection of AWW at the concerned AWC open quotation is wrong and illogical and hence not sustainable in the eye of law. Unquote. However, the sub-collector felt that he lacked the competence to cancel the appointment of the present appellant and therefore declined to pass any further orders. Paragraph. Agreed by the said order dated 10/12/2010, respondent before filed writ petition civil 716 of 2011, which has come to be allowed by the impugned order by the single judge. Remanding the matter again to the sub-collector. This court has heard the submissions of Mr. S.K. Dalai, learned counsel for the appellant, Mr. Kuntia, learned counsel for the state. Despite service of notice and a lawyer having entered earlier appearance for respondent before, none appears for respondent before today when the appeal is called out. Paragraph. The fact of the matter is that while at the time of filing of the appeal before the sub-collector, the guidelines governing the selection of AWWs envisaged appeals being filed before the sub-collector, in terms of the revised guidelines. Issued in 2010, is it?
10, Lordship. 10.
On 10th March 2010, the appellate authority is the additional district magistrate, bracket ADM. Full stop. Therefore, the sub-collector was not in error in observing that he lacked the authority to issue any consequential order cancelling the selection of the present appellate. paragraph. The appeal ought to have been filed, considered only by the ADM, paragraph. Consequently, the impugned order of the learned single judge remitting the matter to the sub-collector would be erroneous. Full stop. If at all, respondent 4 has to be relegated to the ADM to file a fresh appeal. Full stop. Can the ADM consider the appeal already filed?
No, Lordship, they have not filed any.
No. The appeal filed before the sub-collector, can it not just be transferred to the ADM? Let the ADM deal with that appeal.
What has happened in this case, my lord?
I have already served more than 15 years, Lordship, hardly.
What has happened in this
That is-
case, my lord? The sub-collector has rejected his appeal, has passed the order in his appeal, taking to the earlier guideline, that is of 98 guideline. In that 98 guideline, there is no provision for appellate authority, sub-collector or ADM. That subsequent guideline, 2007 guideline, speaks the sub-collector will the appellate authority, that has been subsequently changed to ADM. And he, without referring the matter to the ADM, he has passed that saying that he has no jurisdiction. This is the position, my lord. What has happened
So
next
what should happen now? Question I'm asking is,
may I take instruction to that effect if after the order of this or my lord, whether ADM has taken up this?
no, there's a status quo passed by this court. So ADM would not have.
Yes, ma'am.
This is an interim order passed in the appeal. So nothing would have happened. No, should this appeal itself, which was filed before the sub-collector, should it be placed before the ADM now? That's the question.
Yes, ma'am.
All right. The appeal filed by the respondent 4 being ICDS appeal number 1 of 2008. Is it? Yes, 1 of 2008 will be now considered by the ADM ADM of which district will be?
Birma,
Sonpur, ADM Sonpur. Afresh in accordance with law in terms of the relevant guidelines. Full stop.
If faculty is interested, Lordship.
The matter will be listed before the ADM. The above appeal will now be listed before the ADM on 14 November 2022. Full stop. If respondent before, who's the appellant, does not appear before the ADM on that date, then the appeal will stand dismissed on that ground itself. If she does appear, then the ADM will dispose of the appeal after hearing the present appellant and the state authorities within a period of 4 months thereafter. Full stop. Till such time, the status quo as of today will continue.
Lordship, oblige, Lordship.
The appeal is disposed of in the above terms.
Supplementary list item 44.
May I please? Merit, this writ appeal involves only question whether my VRS application back in 2010 would be allowed or not. The Honorable Single Judge had disallowed my claim on the ground I am not eligible, which is contrary to the records itself. The only limited point which I draw your attention, page 19. The department has never rejected on the ground of eligibility. Department didn't consider it on the ground. The VRS application which is submitted in terms of the 2003 scheme is not available. But subsequently government clarified that 2003 scheme itself is available. Now kindly turn to page 19, the 2003 scheme itself. Eligibility at page paragraph 7, page 19 of the writ appeal. Let's got it.
No, one of the grounds on which your application has been, writ petition has been dismissed is that you've already
superannuated. The difference would be I retired in 31st January 2012. My application VRS was in 2010, July 2010.
My lord, if at all I am eligible, your lordship holds me eligible in terms of clause 8, then my financial benefit should be from 12/7/2010. And I have calculated also how much quality, how much amount I'll be getting on the VRS application. I sought for VRS only on the ground of my ill health. Difference will not be much, my lord, in the VRS as well as the superannuation benefits. Till date, superannuation benefit has not been released.
Why? That's a different issue altogether. Then.
Yes, altogether different.
Only pursue that, sir. If the difference is not much, why do you want to pursue this?
No, only thing that you may say eligible. Otherwise, they will not consider me. Honorable single judge has held. I have 33 years, my lord, page 33. There is no dispute. Already crossed 33 years. This is not the eligibility, my lord. 33 years, suppose the clause itself 8.2 says, if a person has exhausted 28 of service, 5 years, more years will be added so that in any event it will not cross 33 years. But how can I say, my lord, I am not eligible, my lord? Clearly I am eligible, my lord. Department never said I am ineligible. Page 20, your lordship, page 19, last paragraph, 8.8, acceptance of voluntary retirement. 8.1, acceptance to voluntary retirement shall be generally given in all cases except in those cases where appointing authority feels that continuance of the employee is in public interest. That is not applicable. 2, the qualifying service as on date of intended retirement of government servant born under regular and pension retiring under this scheme may be increased by a period of not exceeding 5 years. But the total qualifying service so as to computed for the concerned government servant born on pension shall not in any case exceed 33 years. But how it is really, my lord, I am ineligible, my lord. I came up into service in 1974. 2010, I submitted my various application. And all it has to be accepted within 30 days. All were accepted except me. And honorable single judge says I am not eligible. And the government also says it is a scheme is in.
Who's appearing for the
my senior appears.
That is the clause, and in the meantime, he has retired at the time of consideration of the. So this is only academic because let's see the order page 33. When that matter was decided, by that time he has retired from service.
All right.
So,
but he says even the superannuation benefits is not.
That is other aspect. Direct if not paid, will be paid, but not in accordance with the VRS scheme.
Lord, I am appearing for opposite party number 4, my lord. The text bureau where the employee was.
Opposite party number 4 is who? State Bureau textbook preparation.
Yes. My lord, the single judge has also directed to release the pensionary benefits immediately. And after 2015, the Bureau has intimated the party to receive the pensionary benefits. So we have complied our part of the duty.
When did you communicate? When did you communicate to him to receive the pensionary benefits?
2015, my lord, after disposal of the return.
Then it's up to you, sir.
Yes.
It is up to you to collect now pensionary benefits.
No, I have not.
He says they've already asked you to come and collect your pensionary benefit.
Yes. No, I have not yet received. I have not yet received.
5/1/2015. Letter number 0551.
You say with the petitioner, with the appellant already having superannuated in the meanwhile, the question raised about his eligibility for being considered for VRS has become academic. Counsel for the appellant nevertheless states that the appellant has not been given his pensionary benefits.
Superannuation benefits.
Superannuation benefit till date. Counsel for the opposite part, respond before, produces a letter dated.
Letter dated 5/1/2015.
Addressed to the 5/1/2015, addressed to the appellant, stating that he should submit his OCS pension form 7 and 8 and calculation of gratuity in the office for sanction of the retirement benefits as per the Bureau's norm. Copy of the said letter has been handed over to counsel for the appellant, who is now full stop. It will now be open to the appellant to follow up on the said letter and collect his superannuation / pensionary benefits in accordance with law. No further directions are called for. The petition's appeal is disposed of.
Only I prepared within the time your system picks up so that they can.
You first go there, sir. You're not even gone there.
Item 45.
Item 45, my lord, the petitioner died in the meanwhile.
All right.
I am permitted to file substitution petition.
No, not now, sir. Defects have also not been removed. What is the matter about?
The matter is, my lord, non-payment of suspension allowance. The legality has been challenged.
Now what will remain, sir? I'm sure he's retired by now.
My lord, I am permitted to file substitution petition. My lord.
No instruction.
Defects have not been cured for more than 7 years. It appears that the appellant has also died.
I'm the petitioner, my lord. I'm petitioner.
There's a writ appeal, sir. So we'll call you as appellant.
I am permitted to substitution petition.
Sir, when did he die? You can't, when the matter is called up, you just simply say he's died.
Today morning, I received message that he died in the.
So we don't know when he's died.
So when the matter is listed, I informed to the client, but the relation told me that he expired, my lord. So I am permitted to file substitution, my lord. It's not. It's legitimate.
Let's see what the matter is about.
The matter is a legality of a suspension order passed by the governing body.
Let's see.
By ignoring the rules and regulation of the college, my lord. The college lecture.
Let us read the impugned order, sir.
He's holding wrong brief, my lord. He's holding wrong brief.
What is all this happening, sir? You're appearing in any matter. What is this going on?
This time, Vishnu Priya Mahapatra.
This is Suresh Kumar Naik. 305.
Suresh Kumar Naik? No instruction. He's saying no instruction. Item 45, no instruction.
No instructions. All right, dismissed.
Supplementary list item 46.
The memo is taken on record. No instructions, dismissed.
Supplementary list item 47.
My lord, not precise because the petition is already dismissed and that has been challenged, my lord.
All right. Not precise having become effective. It's all right. Dismissed.
Item 48.
48, my lord, the petitioner died in the meantime. Permitted to file substitution petition.
See what this is. Counsel, the appellant states the appellant has died and he wishes to bring on record the legal representatives. At his request list on 21st.
Supplementary list item 49.
Memo is taken on record. No instructions, dismissed.
Item note 50.
50, Lordship, at this stage, it is not maintainable in Article 227. Lordship, permit liberty.
Since the appeal is not maintainable, it is dismissed as such, with liberty to the appellant to seek other appropriate remedies in accordance with law. Right.
I am present for the respondent.
All right.
Item 51. Item note 51.
None appears dismissed on opposition.
Item number 52.
None appears.
52, Lordship, I am for OP number 2 and 3.
All right.
Item number 53.
None appears dismissed on opposition.
Supplementary list item number 54.
None appears dismissed on opposition.
Item number 55.
None appears dismissed on opposition.
54 not this one. 54. Infractions, my lord.
All right, 54 in purchase. All right.
Item 56.
None appears dismissed in opposition.
Item number 57.
Same order.
Item number 58.
Same order.
Item number 59.
Respectful submit. I am for the applicant indemnitor, and the writ petition was dismissed. The petitioner was working as a Anganwadi worker in Khutpali Center number 2, Anganwadi Center number 2, under the district of Bargarh. Humbly submit. And during the case, the opposite party number 6, the respondent number 6, objected before the sub-collector as to the residential certificate that the petitioner has brought the false residential certificate because has brought the fraud residential certificate. So he made an application before the sub-collector as an appeal, and the same appeal was made dismissed. Again, the same, the respondent number 6 preferred an appeal before the collector of Bargarh. Collector Bargarh on in appeal case number 15 of 2012. Please to find. And the collector disposed the matter on 20th July 2012. So, my lord, here is a crux, my lord. Whether the collector can entertain for second appeal. So far, the miscellaneous certificate rules 1984 clearly provides and envisages the Anganwadi appeal number 21 and like to the 46. So for the annexes 3 of the writ petition, my lord, 17562, my lord, 2012, 813, the Anganwadi appeal number 46 of 2010, the ADM has already decided there. So
what is the order you have challenged in the writ appeal, sir?
Writ appeal, I have order of the collector, Bargarh, my lord.
No, in the writ appeal, sir. What have you challenged in the writ appeal? You must have challenged an order of the single judge in this writ appeal.
Writ appeal.
Which is the order of the single judge that you have challenged?
That annex one, my lord. WPC number 17562 dated at distrust of my honorable single judge on dated 9/3 30th of June 2015, my lord.
Just read that order.
Order in counsel for the petitioner and counsel for the state. Pursuant to the order dated 13/5/2015 of this court by Deputy SP Vigilance Bargarh Unit Bargarh has submitted his report in court today. The same shall be kept on record. Peruse the aforesaid report. It is open to the Vigilance Department to take action on the matter against the petitioner in accordance with law.
What is wrong with this order? What is this order? Such an innocuous order. Why have you challenged it?
Humbly submit, my lord. Humbly submit, my lord. The appellant was initially Anganwadi worker.
What is this order, sir? Some vigilance, DYSP vigilance has submitted a report which has been asked to be kept on record. What is wrong with this impugned order? There's nothing in this impugned order. It's not even disposing of the writ petition.
Lord, I am to submit that the appeal supermacrosis certificate in residence certificate, issuance of the residential certificate.
So nothing is discussed in this impugned order of the single judge. The only single judge's impugned order simply talks of some report of some DYSP vigilance branch.
My lord.
It does nothing more.
My lords, if I may, there is in fact another writ appeal was preferred, which my lords will find at page 14, where, my lords, the honorable court.
That is over. That is over already.
And there they said that since it's premature.
Yeah, I don't, this present writ appeal has no meaning at all. The impugned order of the learned single judge merely takes on record a report submitted by the DYSP vigilance branch.
Honorable submission.
And states that it will be open to the vigilance bar to take action against the appellant in accordance with law. Then it considers the appellant is unable to point out what is wrong with the impugned order, which calls for interference. Even this court is unable to appreciate any legal infirmity in the impugned order that calls interference. The writ appeal is accordingly dismissed.
Supplementary list item 60.
60 to 65, no instructions.
No instructions, dismissed. 60 to 65.
Supplementary list item number 66.
May I please your lordship, my lord? My lord, the present PIL has been filed by Chittaranjan Mohanty in person, my lord. Yesterday he became ill, my lord. So
all right.
On him, I filed this booklet.
All right. What's the matter about?
My lord, my humble submission before your lordships, I filed an application to the government, that is Annexure 1, my lord.
This has already come up earlier, sir.
My lord, that has been already disposed of with a direction to file a better writ application, my lord. So accordingly, I filed a better writ application, my lord. Only my representation is pending before the government for giving the list of political prisoners.
Yes, they want political prisoners during the emergency time and to give health benefits.
My lord, on that ground, only health benefit. If they will give the list of the prisoner, my lord, they will get the benefit.
Do they have such a list, sir?
My lord, there is a list, my lord. But according to, my lord, I have also annexed, that is Annexure 3, my lord.
No, which, according to you, who is not getting benefit? How do you know which are the persons not getting benefits?
My lord, for example, my lord, from last 2 to 3 months, my lord, one Rabindra Narayan Singh, my lord, was died, my lord, who was also prisoner, my lord.
No, is there anyone alive today?
My lord, due to died for not sufficient health benefit in the.
So today, do you know any person who's alive today who needs this health benefit? Are you aware of any such person?
My lord, there is some person, my lord.
Who is which person, sir?
My lord, so on that ground, my lord, I preferred an application, my lord.
No. If you know number of persons who have to get this benefit, it's better you make a representation saying give benefits to these people.
My lord, that is Annexure 3, my lord. That is Annexure 3, page 25, my lord.
No, of this.
Well, that is the list. That is the list of the prisoners, my lord.
Now, who's going to undertake, and why are they not coming forward?
My lord, because the present Chittaranjan Mohanty has preferred a many writ application for a public interest.
No, all that is fine, sir. We are dealing with other also PILs of his.
My lord,
has any of these persons come forward? Do they need help? We should not presume they all need help, sir.
My lord, my humble submission, my lord, I have also filed a application under the ATPA Act before the several jail superintendent of jailer, my lord, to give the list of the prisoner, my lord. But they stated that we are unable to supply the information. So on that ground, I preferred an application to the state government. Only consider my representation.
No, it should take you somewhere, sir. If they are also equally clueless as to how to go about this, then we're only going in circles.
My lord, can I pray, my lord? Can I pray, my lord? One thing, my lord. Lord, suppose, my lord, if my application has consider my application. If suppose there is no list, then they communicate that order to the present petitioner. Only on that ground. Consider my application. I am praying nothing else, my lord. Only to Annexure 1.
Well, the first thing to ascertain is whether there's a scheme in place, because there is no scheme as on date, my lords, to ask that such a
No, but unless there is such a list prepared or kept, where's the question?
Well, that from the RTI that he has filed, we don't have any list in the, at least in the jail. So,
And this is a 2019 representation, sir.
Yes.
If you directed me to fresh representation.
You make a fresh representation.
The
The copy of the representation placed on record. Representation made by the petitioner to the government, which is placed on record, is dated 29th November 9, 2019. Nearly 3 years ago. Full stop. There's also no proof of such representation actually having been delivered. Full stop. Consequently, permitting the petitioner to make a fresh representation. And after following up on such a representation, to seek appropriate remedies in accordance with law, the petition is disposed.
My lord, it may be disposed of, my lord.
Disposed of, that's what.
My lord, that application, representation.
No, you make the fresh representation first.
Oblige, deep oblige.
Supplementary list item 67.
Here I'm led by senior advocate Mr. Nanda, my lord. He is on his legs. I pray for a passover.
Tell us what the matter is, sir.
Item 67, I am appearing for the respondents, and I filed an affidavit. The order passed by the Honorable Single Judge has already been worked out. I am giving the affidavit.
No, my lord. By perpetrating fraud, they have got an order. My lord, I place, my lord.
My God.
My lord, may I only for one passover, my lord.
Today I have to
Let him serve a copy of the writ
my lord.
And Honorable Single Judge, without giving an opportunity, my lord, on the same day when my IA for intervention was allowed, on the same day writ application.
No, it has been.
Everything will be placed, my lord. I only pray for a passover.
You will also look to the entire order sheet of the Honorable Single Judge. The matter has been hard time and again. And he was the.
No, my lord, that's a wrong statement.
Oh
my lord, kindly see the record. That's a wrong statement, my lord.
I was so emotional.
On
I've given the.
On my intervention application was taken up for hearing, Honorable Single Judge rendered a finding, yes, you are a necessary and proper party, not only the appellants, but also the other trustees. The trustees are in serious dispute in various civil litigations. Criminal litigations are pending. Now, one of the trustees, misrepresenting himself as the chairman, in the name of the trust, has filed an order without disclosing that he is no more the chairman. Resolutions have been passed. Suppressing all this, he has filed a writ application. Now, our intervention application was taken up. On the same day, Honorable Single Judge allowed our intervention application, and at the same time allowed the writ application.
What is the prayer in the writ petition?
Prayer to allow this person to operate the bank account.
Oh.
And that has been allowed. And as far as
the only ground on which the bank has rejected, because the suit was filed by them, that suit was dismissed for default, that is in respect of a different account.
How do you find these things, sir?
But the writ application was filed. So far as the bank's order is concerned, bank has said because of the rejection of the application for default, so therefore we will not.
But if it's a suit, you'll have to go for application in the suit.
No, so far the suit is concerned, there is no suit at all.
No, my lord, that restoration application. And this person, my lord, is taking time. And
petition be filed against.
Serious dispute.
How is the writ petition filed against Punjab National Bank?
The writ petition was filed challenging the order passed by the Punjab National Bank.
How is the writ petition maintainable?
Because only the order was that rejecting our application.
How is the writ petition maintainable, sir?
The public perspective, that is bank. You also know.
No.
You also allow me to give me a copy of the appeal.
No, just say notice. You accept notice for whom, sir?
I'll respond number 4.
Respond number 4. You say till the next date of hearing. Who's appearing for the bank?
Bank has not appeared.
So, in the copy of the writ appeal, he has received the copy. Mr. Gurudat Karo, who was appearing before the Honorable Single Judge, he has received the order.
Notice to the remaining respondents.
Notice
by registered speed post. Returnable on 5th December. No, 12th December, you said. What is happening to the accounts of the trust in the
I am operating
Since 2016, the banks have put a debit freeze on these accounts. Now in various applications by all of us before the civil court seeking permission to operate the bank accounts have been rejected, and those matters are pending in first appeal before this honorable court. Now in 2022, he comes up as representative chairman and gets an order to operate the bank account.
No, absolutely.
Mind 6 years the bank has not allowed banks are freeze, my lord. So 6 years.
We'll also look to the order.
And my lord, to genuine difficulty
If
of
I not to do like this, I have nothing to say.
No, my lord,
judgment.
my lord, kindly see the anxiety. I have offered them a copy of the writ appeal. They say no. Now, on the very first day, they comes up with a counter affidavit. No, I'm not on that. My lord, kindly see.
Wait, we'll examine all of this. You say notice returnable on 12th December. You say, no, what should be the interim order?
We also see
that needs to be straight because last 6 years,
last minute.
Last 6 years,
the bank for at least for a woman. What is this? This is an institution. This is a medical institution which is operated by the petitioner, and you also see the entire order sheet. And this has been operated for last 10 years. You also look to that.
No. The Neelanchal Mission Trust.
Yes, sir. Yes, sir.
Who's representing?
Myself. We also look to the who is of the writ application.
Yes, my lord. That's I say it's on suppression. He's not the chairman. He's no more the chairman. He's representing that he has come up, and that's my only in the intervention application. Kindly see, that's my only averment. That by suppressing, by misrepresenting how
I also see that order has been worked out. I have been allowed to operate, and I have already
now they are saying that it's been worked out.
1 minute. In the writ appeal memo of parties,
I have not.
He has not included me as a party. He has included us in person.
My lord, I have filed an IA for that. My lord, I have filed a separate IA. Why I have not included a trust as a party? My lord, kindly see the impugned order. The honorable single judge has held that trust is not required to be made a party because it is the trustee dispute and all the trustees are to be made parties. That's why I have sought an liberty to add other trustees also. My lord, kindly see the other trustees were also not made parties by him.
Petitioner is the
trustee is not a necessary or property in an inter-trustee dispute. The honorable single judge has held that.
Petitioner.
So I am following the honorable single judge in that aspect.
Read petition is printed by the trust. The trust has not been made a party.
It is not. Kindly see the honorable single judge order. There are one honorable Delhi High Court order, honorable Calcutta High Court order, which the honorable single judge is referred to and said that in case of an inter-trustee dispute, trust is not required to be made a party, and it is all the trustees are required to be, which they have not made in the petition and got an order. And that's what, my lord, has been held by honorable single judge.
Here there is no question of inter-trustees dispute.
Exactly, my lord. The civil suits.
And how is it a writ petition, sir?
Seriously, my lord, disputed questions of fact.
But these kind of
and not only
if you also look at the writ application, what was the challenged?
What is prayer 5 in the writ petition? Because it says that in order in terms of prayer 5.
Prayer 5 is allow me to operate all the bank accounts of the trust.
You also look to what is the order of the bank, which was the subject matter of challenge. You also look to that. That is the difficulty.
There shall be a stay of the impugned order of the single judge till the next date. All right.
Yes. So for the operation of this is an institution. This is an institution. That is the problem.
I only
whatever was the position before you went with this petition, that will continue.
You'll also clarify that. That's all.
My lord, may
you also clarify that. Whatever the position prior to the writ application, you also say that so that who was
again controversy which they want to
No, my lord, I don't have to say that. You can come forth and ask us for more clarification. And as far as we are concerned, we're staying the impugned order.
Application is pending. You appeal there. The civil suit is pending, my lord.
Yes.
You appeal there. My lord, application. Next day, when this person is awarding notice and
all right.
My lord, I am obliged, my lord, that my lord has issued that notification that by email it can be served. Then that is how I could serve upon these persons. Otherwise, they refuse notice in the lower court, my lord.
All right.
Obliged, my lord.
You'll also be fixing a date. Otherwise, the whole difficulty is the
5th December, 12th December.
12th December till that date, the operation bank will not be allowed to the trust. Then how this?
So we'll see you. Those who are affected will file applications.
See, you also get that liberty. So that otherwise,
there's no need for liberty. Always, I think applications are always filed, sir.
Maladi, one of the appeals pending.
Then my You're not allowing me to at least.
No, my lord, I'm not. One of the FAOs pending before this honorable court. Honorable judge has allowed them. If any of the parties face any difficulty, you come for modification of this order. In FAO that is pending before this honorable court.
Something which is not on record. There is no matter pending before this court. So far the suit is concerned, suit has been dismissed for default. He is the plaintiff. He has not filed any application even to restore the suit. No, my taking time and somehow to see that
filed on the very next
account to not be operated.
Date of dismissal 4/12 is the date of filing restoration application, and this person only who is awaiting. Every other person has appeared. Yesterday, my suit was there. I have taken paper publication, my lord. Yesterday, civil suit was there before the district judge Bhubaneswar. I have taken for paper publication, particularly for this person and his wife.
All right.
Supplementary list item number 68.
May I please, Your Lordship? In item 68, my Lordship, the present petitioners who are working as driver Havildas, they are challenging the Rule 23(1) of 2021 rules under Annexure 8. The relevant portion is at page number 117, Your Lordship. Uh, 23(1) with regard that states promotion to the post of assistant station officers. Appointment to the post of assistant station officer in a year shall be made in a following manner, namely A, 75% vacancies by promotion of eligible leading firemen.
Will anyway issue notice, say notice. Mr. Kunti accepts notice for the opposite parties. States that he'll file a reply within 8 weeks, rejoinder for the next day. From 19 January.
Great.
Right.
Supplementary list item number 69.
None appears dismissed for non-possession. Aye.
Supplementary list item 70.
This is regarding the High Court staff. Now, here some developments are there, man. I'll just draw my lord's attention. The High Court on 25th of March had requested for in all 959 posts in a phase manner. If my lord would see, I'll given that both the letters.
And now they've agreed to some posts.
Yes. So they had given clearly that in the first phase, they want 494 people. Against that, they have agreed for 228.
228 posts have been created.
So I have been always saying that once the High Court makes a request, they should normally accept it. This kind of a bargaining is not probably what is visualized in the Constitution. That judgment also, if my lord wants, I'll just show that 2004 1 ACC 330 for the convenience of the state. He knows that, but I need to show that whenever the High Court makes a request, unless there are major exigencies, that should be allowed. So now what they have done, against 494 for the first phase, they have granted 228. And this plea that there are financial exigencies, that may not work so far as the request of the High Court is concerned. There is one paragraph in that judgment.
No, I think in our letter itself,
my lords,
in the first phase, 248 posts.
No, if we add that first year.
No, first phase /year, 248 posts. And in the second phase year, 217 posts. And the third phase, separate sheet. So of the total 494, 222, according to us, 248 had to be created. They've created 228.
No, I have been told by lords, by the registry, I think if we add up the first year itself, it's more than not 248. My lords may see the page, first year. If this is added up, in fact, serial number 11, 12, 13, that itself.
No. This is for all 259 posts.
Yes.
959 posts.
Correct.
I think of those
959 in all, for the first year, it was 494.
Out of 494, that two phases.
220.
494 in the first phase.
So what I have been instructed by the registry is that they are facing some problems for the balance. So this 494, if they can clear at a...
Well, take time, listen to that effect.
All right.
Because there's one judgment which makes it clear that this financial stringency is not an issue. That they cannot bring in. My lords, may I just show that paragraph?
We have not taken that decision on in view of financial.
That's what I am told that they have basically dragging their feet on the ground of financial stringency. 2004 1 SCC 334 paragraph
No,
7.
that is not what they're saying. Let's not presume that they're saying that. All right. You say the court has been shown copy of a letter dated 8 September 2022 of the Home Department Government of Orissa creating 228 posts, bracket growth, promotional and base level in the establishment of the High Court. In response to the request made by by the High Court, by its letter dated 20 March 2022, whereby in the first phase, 494 posts were asked to be created. Paragraph, Counsel for the State seeks some more time for instructions on when the remaining posts as requested would be created. List on. We'll have it in January. January. 30th January. All right. 30th. All right. 1 o'clock. No? Yeah, with just 5 more minutes, we can finish some more matters.
Supplementary list item 71.
71. All the annexures are
coming physically on VC. Then that's
the Odia annexures, and I have to file the translated copy of the Odia annexures, except page 13. All are Odia annexures. So if your lordship take up, then permit to me to file the translated copy of annexure, then is a public interest litigation.
No. What is the prayer, sir?
Prayer means, my lord, the government now is going to, government means that is the enhance the pensionary benefit to the ex-MLAs. He is a petitioner, is a social activist, and he submits that the tax, ultimately the burden will be vested on the taxpayers. So this should not, she is opposing not to enhance. This is going.
Why should she enhance? I don't understand.
That is the ML, there is a pensionary benefit of the ex-MLAs.
So why not? What is wrong with that, sir?
Wrong means this is the now the corona, after the pandemic corona, this is the financial condition of the state is now.
Why is he worried about that? Why only target one? That government employees, everybody should be worried then.
Because they are they are the public leaders and the political leaders, they are coming forward so much to serve the society. So, now they are demanding the pension and thereafter enhancing the pension.
Why not? What is wrong with all that, sir? What is this perception? I don't understand.
Yes, file.
What is this perception? What is this perception? Look at your prayer. Just come to your prayer.
Yes, prayer, my lord. Public, my lord.
Such a vague prayer, sir.
Yes, my lord.
Which is going to be taken.
I don't know. Not taken yet.
Because the decision, that is the decision under Annexure 1, they are going to.
What is that going to? We don't even know if they have.
That's why.
Yeah. We can't have a premature petition like this. The prayer in the present petition is premature. It seeks to challenge a decision which is yet to be taken.
Yes, obliged.
Consequently, the court is not prepared to entertain the present petition. Is dismissed as such.
Supplementary list item 72.
May I please do this? Here, the only question which involves here that this relates to appointment of the assistant professor in the post of surgical oncology mallet, where the qualification, educational qualification and requirement that has been misread by the college as well as the honorable single judge. May mallet place the only clause which this case rests on. I have given the copy of the Medical Council of India minimum qualification of teachers in medical institutions regulation 2017, and this clause has been copied down in that advertisement. Mallet.
All right, we'll continue after lunch.
Mallet.
This will take time. Right. Right.
Sir, it has to be taken in regular means. Bail we can take up.
Yes, all right. What's your ground for bail, sir?
So my ground that the lady, she has been charged for double murder, case of maternal felicity, and she has been convicted for life.
No, since how long has she been in jail?
She's been in jail since.
Judgment is 2010.
5/11/2018. 5/11/2018. From the date of arrest, she is in custody. 13 years, 11 months, 16 days exactly.
Sorry?
13 years, 11 months, 16 days as on date in custody.
13 years, sir.
13 years. So we can consider that, sir. She's a woman.
Male child.
I know, sir, but
And husband is the complainant.
13 years. No, 13 years. So.
Your Lordship, we can grant.
Right. You say this is an application for bail by the sole appellant, who's a woman charged with murdering her minor daughters by drowning. Full stop. She has been in custody. She has served so far 13 years.
11 months, 16 days.
11 months and 16 days in jail since her arrest on 5th November 2008. Full stop. There is no prospect of the present appeal being taken up at an early date. Considering the judgment of the Supreme Court in Singada Singh, the court directs that the appellant be enlarged on bail during the pendency of the appeal, subject to the satisfaction of the trial court. The application is disposed of.
Your application will be the appeal. Sir, other application will be had along with appeal.
The main appeal, you say the paper books be prepared and supplied to the parties within 8 weeks. The IA number, what is that IA number?
86 of 19 for additional evidence. That is essential. That is essential, sir. We have taken a ground.
You have an objection to that?
No, my lord.
All right. That application is allowed. The additional evidence is permitted to be led as prayed for. The appeal be included in the list of final hearing matters after supply of paper books. All right. Right.
Paper book, sir, appears to be already prepared.
It's prepared, is it? All right. All right. Okay. Okay. All right. You can take that.
Sir, I take leave, sir.
All right. All right. Namaskar. Namaskar.
Supplementary for orders item number 1.
My lord, see, my lord. Here, my lord, the appellant was convicted under section 320 and custody about 9 years, 7 months, my lord. And as far as allegation is concerned, my lord, while the decision is sleeping on the court, the present petitioner, being armed with the axe, bow, and arrow, assaulted by means of axe and ready by my lord. The civil dispute only here, my lord, only basic upon the one child witness PW8. That case has been convicted.
How long has he been in, sir?
My lord, 9 years, 7 months, my lord. 3 months.
Are you ready to argue the appeal? Then the appeal itself can be heard. The paper books are ready, no?
Yes.
Paper books are ready, sir.
Paper book is not collected, my lord.
You collect the paper book?
My lord.
Are the paper books ready?
Yes.
Paper books are already ready. You say the court is not inclined to consider the bail application at this stage, since the paper books are ready and the appeal itself can be heard. Main criminal JCRLI 8 of 2016. We can give you a date right now if you're ready to argue.
Except debt lordships.
I'm sorry?
Except a debt lordships.
All right. The appeal be set down for final hearing on 15th November 2022. The paper books be collected by counsel for the appellant in the meanwhile. Right. All right.
Item number 2.
Your my lord, the father-in-law and mother-in-laws, they have filed interim application for their release on bail.
being convicted under 4B, 498A of IPC, along with 4 of Dowry Prohibition Act. My lord, here the sentence is under section 304B, sentence is life imprisonment. Whereas there is no charge framed under section 304B of IPC while the trial started. And these in-laws, my lord, their father-in-law and mother-in-laws, they are in custody for more than 3 years, 10 months.
How old are they, sir? What is their age?
My lord, they are 60, more than
Time 62 and 57 at the time
at the time of filing the case.
2019.
Now they have 65, 60.
2019, one was 62, one was 57.
What are the ailments? Is there any medical condition?
Doctor is PW 15, my lord, 14.
Don't be the appellants.
No. Any report of the medical condition, because you say they're suffering from various ailments. Is there anything on the medical condition of the appellant?
My lord, my instruction is that they are receiving treatment inside the jail, but those papers are not given to us.
I can take instruction on that, my lord.
All right. Counsel for the state needs time for instructions on the medical condition of the 2 appellants. Public appellants. At her request list on. We'll have it Friday following.
Oh, please.
Not this Friday, the next Friday.
Monday, my lord, Monday.
No, Friday we can have it, sir. 30th September. All right.
Item 72.
My lord, I would like to draw my lord's attention to page 14 annex 1. My lord. This was the advertisement, my lord, which was issued by Acharya Harrier of Cancer Hospital for filling up certain posts of assistant professor, where this petitioner, this appellant was the applicant for surgical oncology at clause 6, my lord, where under ST category, 2 posts were advertised, and he was the only candidate who had applied for this post under ST category, my lord. My lord, may kindly come to clause 3B, my lord. This is important, my lord. 3B on the same page.
Yes.
My lord. For super specialty departments, MD or MD or MS plus MCH DM, MCH DM degree will be preferred. The next para, my lord. He or she should have PG degree in super specialty or PG degree in concerned broad specialty as per MCI with 2 years special training in the concerned super specialty. Also, the candidate should have 3 years teaching experience as senior resident in the respective discipline from recognized medical institution recognized by the MCI. This appellant has 3 years teaching experience in the post of senior resident from the same institute, my lord. My lord, this has been copied down from MCI guideline, which, my lord, I have given. My lord, may kindly peruse that. That is, my lord, page 3, my lord. Page 3. This professor, a professor, my lord, got it?
Yes.
My lord, the second column, my lord. MCH bracketed surgical oncology / MS surgery. I am MS surgery, my lord. Then what they say, they have given a slash and again written or. These are 2 parts. Either a person should be MCH surgical oncology or MS surgery, or this is one part. And second part is, if he is MS ENT or MS orthopedic or MD Gynac they need to have 2 years special training in the surgical oncology. This is what has been copied down from here to the advertisement, but no comma, no full stop, no slash, no or has been mentioned. And this has been misquoted and misunderstood, and basing on which my candidature has been rejected, even though I am eligible as per MCI guidelines.
No. What has been misquoted and this 3B does not have all this.
But they say that basing on this MCI guideline, this 2 years, my lord, may see, they have added 2 years of special training, where this MS surgery do not have to need this 2 years special training, because I am from surgery department. I have that experience, and in addition to that, I have already worked for 3 years in the same discipline, the surgical oncology. So I am excluded for having this 2 years special training, my lord. That is what the MCA guideline is.
No. Here, this 2 years special training is for everything.
They say that everyone has to have this 2 years special
Correct.
training.
Even the MCA guidelines indicates that only, sir.
No, my lord.
That with 2 years applies to all those categories.
No, my lord.
Yes.
May I place once again? Well, this is the crux of the matter, my lord.
Yes.
MCH surgical oncology / MS surgery.
Yes.
Then they have given a slash or. The upper part is different and or. This 2 years is applicable to MS ENT or MS orthopedic or MS gynec. Why this is required, my lord? Because that ENT guy doesn't have any experience of this surgery on abdomen, and this my lord, then orthopedic, my lord. Orthopedic also, they don't have this experience of on abdomen, and again this
no, but if they omitted, sir, what the problem is in the advertisement, if they've omitted all these things, they've consciously omitted it.
No, my lord, no.
They have not lifted the MCA guideline per se.
No, my lord. The order which has been passed by the single judge has dealt with this only. As for MCI, I am not eligible, because, and my lord, what they say in the first paragraph, the selection will be as per OEMS rule 2009, my lord. The first paragraph of that advertisement, and OEMS rule I have given, my lord, another copy, my lord. My lord may kindly peruse. The first paragraph, applications are united in the prescribed format for the eligible candidates for the post of assistant professor in following discipline, work as such and such. The applicant will be in accordance with Odisha Medical Education Service Method and Recruitment and Condition of Service Rules 2009, my lord.
Right.
My lord, that I have given a copy, my lord.
Right.
My lord. There, my lord, may kindly come to page 3, my lord. Eligibility criteria for post of assistant professor.
Right.
My lord. Selection shall be made through the Odisha Public Service Commission from amongst the tutor and senior resident having PG degree in same discipline with 3 years teaching experience as such. This is the criteria which I fulfills, my lord. What they said after this 2009 rules, this 2017 MCI guideline has come. And even, my lord, if would come to page, my lord, may kindly, my lord, page 12, page 23, my lord. 23, my lord. This is the previous advertisement of the same institute.
Right.
There they say eligibility. My lord, second, third column, second one.
Correct.
PG degree in the specialty with 3 years experience in senior resident in the respective discipline, which is according to 2009 rule, my lord. My lord, the next page, another advertisement, my lord. It has been same eligibility has been fixed. My lord, the 24 page 24, my lord.
Correct.
My lord, the next page, another advertisement, my lord. 2015.
Right.
Educational qualification, here she should have PG degree in the specialty with 3 years, same one as per 2009, my lord. Now, my lord, the next page also another advertisement, it's same. My lord, may kindly have a glance at page 29 now. My lord, got it?
Yes.
Here, my lord, as because this 2000 MCI guideline came, they have changed it this way. My lord, clause 3, my lord, educational qualification. MCH, surgical oncology or equivalent, or MS surgery or equivalent postgraduate degree recognized by MCI with 3 years post-MS experience in surgical oncology. Basing on this, I was eligible. I had also applied for that. For some reason, they withdrew this, and they have issued that impugned advertisement in the year 2021, my lord. But typically this relates to this MCI guideline. That is the only thing which need to be seen, my lord. The MCA, and I did not make a MCA party because it is clear, my lord. It's a fact, and this has been followed by all through this all other institutes.
No, you have 3 years post MS experience in oncology.
Surgical oncology in the same institute. I have completed 3 years. May I place that again? That professor side the MCA guideline which says, that is clear, MCA surgical oncology / MS surgery. Then they have given a slash, and in addition to that, they have given or. That is the reason why they have given slash as well as or. That's why.
No. You have 2 years special training in surgical oncology. You don't.
They want me to have 3 years in oncology. In addition to that, 2 years special training, which is not available even. I have already worked for 3 years in the same institute, in the same department as senior resident, my lord. These are required for departments which they have mentioned. That is orthopedic, ENT.
So that slash or is what you are saying is the difference.
My lord.
What does the single judge say?
My lord, they say that I should have this 2 years special training, my lord, which is not available also. Special training in addition to this 3 years teaching experience in post of senior resident, my lord.
Oh, there were 3 petitioners, is it?
My lord, I was for ST, another for SC, and the third one for UR category. And the most important, interestingly, my lord, there was only one candidate, that is ST, who was one candidate was available for one vacancy, and SC, one candidate was available for one SC category. There were no other candidates available for you.
But somebody has got selected or nobody's got selected?
No, my lord. I was the only candidate available. Only candidate applied also. That, my lord, I have also annexed at page. Page 22, my lord, of the writ petition, my lord. I have got it under RTI.
So this the understanding of the responses that the special training is required by everybody.
That is what, my lord. On bare reading, my lord would find I have done my post graduation in surgery. My lord, generally it is known what surgery is. Then in addition to that, I have 3 years experience in surgical oncology. Then what extra 2 year experience I need? And there is no those kind of training is available.
Having done MS surgery, you've also worked in the Department of Surgical Oncology.
For 3 years. The same institute. And well, it's clear that is orthopedic. And my lord, they have deliberately mentioned ENT. ENT doesn't have anything to do with surgery.
We'll issue notice. Issue notice. Notice be served. In addition to counsel who appeared for the respondents before the lunch signature.
Only predicament is that I had filed one IA yesterday. It has not come. Meantime, they have issued another advertisement, including this post. That IA, I have the number.
What is the last date for that advertisement?
Application last date is today.
Today, is it?
That IA number 3055. May I can this be listed tomorrow, my lord, this IA? Or
we'll take it on board. This IA
305522.
3005 of 2022. It's a notice on that as well.
my lord is posting it to.
That's what we'll just see which is the earlier date we can give. Maybe next week we'll try. 28th September. 28th.
I pray for some interim order if they will be filled up. my lord.
How can between today and next week? I don't think we'll fill up.
Okay, deeply obliged. Deeply obliged.
Supplementary list item 73.
May I please, madam? Lordship, kindly see at page 9 of the Honorable Single Judge Order, madam. That is impugned order. Considering, I may read, madam, page 9. Considering the submission of Lord and Counsel appearing for the petitioner and the examination involved herein is for 2009 Car Festival, this court finds no scope for entertaining such request at this stage. Consequent petition stands dismissed, my lord. My prayer was before the Honorable Single Judge, my lord. Kindly see page 16, my lord. Subject. My prayer is to publish the result for audition test for empanelment as running commentator for live non-sports events like car festivals, etc. in Odia language. My humble submission, the Honorable Single Judge has wrongly confined to only relates to 2019, my lord. That is
this
not correct.
empanelment is valid for how many years?
This empanelment means, my lord, since I have been empaneled.
The valid for how many years?
That panel is normally valid for how many years?
How many years have not been stipulated, but since once I have been empaneled, if necessary, they have called me. But it is not confined to only 2019 examination.
No, you're already empaneled or you've never been empaneled?
I have never. This result has not been published till date.
All right, notice returnable. 22nd November.
Obliged.
You are appearing for the
he accepts for
1, 2, and 3.
1, 2, and 3.
Yes, yes.
How many more respondents are there?
1, 2, and
3, my lord.
So what do you say, sir?
I don't have any instruction with regard to the empanelment. I have heard my lord's query. I have to take yes.
All right.
Supplementary list for orders item 74.
One lord, the petition has convicted under section 302, 304B, 498 and 4 DP Act.
Right.
Lord, I have filed a IA for bail, my lord, because my lord, the petitioner is inside custody since 31.
Why don't you argue the matter, sir? We are here ready to hear it today itself. Paper book is ready.
Your super argument. Next week, your lordship may fix that.
All right. Counsel for the appellant is not ready to argue the appeal today. At his request, we'll have it after the vacation, 17th October.
Obliged.
Supplementary list item 75.
If I may please your lordships, my lord. My lord, the appellants have challenged their conviction under 302, your lordship. My lord,
it's not admitted yet.
My lord, notice was issued and LCR was ideally called for, and I'd made the submission.
It's been admitted.
It has been admitted, your lordship. So, your lordship, I have filed applications for bail and for stay of the fine amount, your lordship.
Fine amount is stayed. Bail is how many?
My lord, for more than 3 years, my lord, no direct evidence, your lordship.
That's all right.
My lord,
bail application not pressed at this stage. If you're ready to argue the appeal, we're ready to hear the
My lord, the LCR has not yet come, your lordship.
Kindly so the LCR requisition paperwork be prepared.
My lord, may kindly keep the bail application pending, my lord, till the LCR comes down, my lord. My lord, there is no evidence, my lord. My lord, the only evidence is that
Why he was... argue the appeal itself then? That's far better. Before us, it doesn't take long.
My lord, in the interest of
We
the
are ready to hear the appeal right away.
my lord, if your lordship desire, my lord, I'm ready. My lord, the only evidence is
Yeah, so let the paper books come. We'll hear the appeal, sir.
my lord, may kindly keep the
At
bail
the
application
request of
pending.
counsel for the appellant list on 23rd November.
My lord, let the bail be pending, your lordship. My lord, may I only
All
pray
right,
for that.
just keep that. Don't pass orders on the bail yet.
Grateful, your lordship.
Item number 76.
Yes, sir.
My lord, I have applied for the intervention petition. I have filed. One of the villages, about 300 people are 12,771 IN number. 12771 of 2022.
Of 2022.
My lord, it is noted also in the list.
I know. We're trying to hunt it down. But what was the last order passed?
Last order, my affidavit, your lordship may see, 18th July 2022. That was handed over to my learned senior, and he was supposed to file his response to this affidavit.
What happened to that, sir?
I
That response to the state's affidavit.
Sir, additional affidavit to
response is filed to your
18th July 2022.
response is filed. I have raised certain objections also there. My lord wanted a response to the counter filed, but the last date was for taking time.
No, the last date is additional affidavit of the state has been handed over to the petitioner.
My lord's order
18 July.
18th July.
My lord's order was 29/9/21. Direction was issued for the protection and for protection of the boundary, etc. That has not been completed, I have stated in my petition. And 72 years after, my lord, a village comes that it is to be included in the area. That is, but 72 years after. Earlier to this, certain villagers come and file petition that they are to be included, and their land is taken by the notification of 1950. But my humble submission to my lord is, from all sides, people are trying to defeat my lord's order. That's what the government, the SI, and the villagers. But in the other side, my lord, I have also filed before my lord the published the land grabbers. They, my lord, they are inside. They are doing all the mischief, and the land is taken by persons of government supporters. And my lord's order has not been fully carried out.
May I submit one thing to my? In this case, the response of ASI is highly required, because ASI is not filing any affidavit and not responding to any of the
I'm
orders.
just clarifying.
Yes.
My lordship may see the order dated 15/11, 15/3/2022. That order, lordship may see operative part of my lord. Last paragraph, paragraph 4. Mr. Mahanti 6 and is granted 4 weeks time to respond to the above affidavit. The state government must come up with because after our affidavit, they come up with a detailed plan on how it is proposes to go about the enforcing the enforcement gazette notification by removing the encroachments and facilitating the construction of the boundary wall around the entire demarcated area of 562.681, which has been notified as a centrally protected monument, my lord. Thereafter, an affidavit was filed by the state, by the Superintendent Orissa State Archaeology Officers Directorate. He is coming with a proposal that the central government, let's see the paragraph internal page 5, continuing page, I don't have, sorry, my lord. This, let's come to the paragraph 8 onwards. I am coming to the next page, my lord.
Yes.
That the prayer of the petitioner is for the demarcation and protection of the excavated, and it is nearby areas. This is also done by the Tahsildar Bhubaneswar in presence of ASI in the June 2021, and pillars have been posted in the demarcated area. The affidavit filed by the Superintendent Archaeological Survey of India before the Honorable High Court is demarcating the entire 562.68 acres of the land notified in 1950. It is humbly submitted that the entire land except 0.775 acre belonging to the private persons. The demarcate the land of the private persons consents of the individual landholders are required. ASI may directed to obtain the consent of all individual landholders in the notified area and file a requisition of the demarcation before the Tahsildar Bhubaneswar with the required formalities like depositing the fee etc. Ultimately, the ASI may directed to require the land notification such and such. I am just clarifying, my lord, the section 19 of the ASI Act, my lord. This section 19 is very much restriction on enjoyment of the property of right to protection. Straightway, I am coming to the subclause 2, my lord. The central government may, by order, direct that any building constructed by any person within a protected area in contravention of the provision of the subsection 1 shall be removed within a specified period, and if the person refuses or fails to comply with the order of the collector, may cause the building to be removed, and the person shall be liable to pay cost of such removal. So collector is the authority to remove all this encroachment and give freehold to the ASI. That was not been done. Otherwise, this might have this.
Not opening up. May I pray one thing? What my learned friend is saying, come up with an affidavit of the.
Just a minute, I may complete thereafter. You can.
So that I can give a response to it, because
Yes,
now it is the responsibility is being.
See, in our additional affidavit, let's see, we come to page 40. Additional affidavit filed by us on.
No, according to you, unless the encroachments are removed, you cannot build the boundary wall. That's what you say.
Yes. Unless until the state will not extend their cooperation in this regard. And we don't have any scope, only except the section 19, the collector have to give a vacant position, then we will go for boundary wall. We have demarcated, we have given Naksha, everything before the court, my lord. We have given the photographs, everything my lords make for use.
My lord,
Mr. Mohanty, now the ball is in the state government.
Yes.
No, my lord, what we have explained, your lordship may kindly have a glance on our affidavit dated 18th July 2022.
Where is that? Where is that 18 July?
That was I am referring to. That was
Para 8. That the prayer of the petitioner is for demarcation. Has your lordship got it? 18th July.
What we have read, my lord. What I have read.
This is not the state government. This is the superintendent archaeologist. ASI.
One Ashwini Kumar Satpathy. OP number 5. Additional affidavit filed by OP number 5. 18th July 2022. In court, we have filed it. Flag Z.
Paragraph 8 of the same affidavit.
I think it is in flag Z.
My lord, I am permitted for one minute, man.
Let's first resolve this issue, then we'll go.
What is it?
Affidavit.
If your lordship allow me, I will read it.
Flag X.
Paragraph eight.
No, no, it is
In that
This is-
affidavit, the state government, this superintendent has filed the affidavit. Instead of superintendent, this collector should come forward to what step he is taken.
Collector is not coming, my lord.
Collector is not coming.
No. Your superintendent is filing all affidavits and all.
This is the affidavit of Amiya Bhushan Tripathi.
That is the petitioner, Amiya Bhushan
Is the
Tripathi.
petition.
Ashwini Kumar Satpathy, 18th July 2022.
Yes, yes.
One affidavit was filed on 17th May, then another affidavit on 18th July. That is important. Mail. LMS. Sir, आपन अच्छी copy था 18th July copy अच्छी था
Yes.
copy is available with my other side.
ASA has never taken steps for acquisition.
No,
Despite
para
different
8.
meetings.
Lordship may kindly go to para 8 directly.
Yes.
That the prayer of the petitioner is for demarcation and protection of the exploited and its nearby area. This has been done by Tahsildar Bhubaneswar in presence of ASI in June 2021. Pillars have been posted in the demarcated area. The affidavit filed by Superintendent Archaeology before Honorable High Court is for demarcating the entire area land notified in 1950. It is humbly submitted that the entire land except 775 acres belong to private persons. To demarcate the lands of private persons, consent of individual landholders are required. ASI may be directed to obtain the consent of all individual landholders in the notified area and file a requisition for demarcation before the Tahsildar Bhubaneswar with requisite formalities like depositing fees, etc. Alternatively, ASI may be directed to acquire the notified area under the Land Action Act 2013. So there is certain procedures, your lordship, which are not complied.
Upon the Land Action Act, it cannot be. It will be acted on the land.
Under any act.
Land acquisition made in 50.
That ASI has suppressed the fact that it did not pay the compensation for 17 so land, which it intended to.
Mr. Padi, unless if the land is in private hands, how will you demarcate it?
My lord, I am just clarifying. Let's may come to the page. What my land can be, might have is not properly instructed. Let's may come to our additional affidavit, page 40. Prior to lot of communications here from the ASI to state authorities, and minutes has been prepared. Page 34 onwards, let's may see that is affidavit dated. That is 24 December 2021. Additional affidavit filed by the OP number 6 and 10. Lordship got it. Lordship got it. The additional affidavit filed by the ASI, Ministry of India.
Yes.
That Lordship, I am statuting my note to the page 40. A letter written by the ASI to the collector and district magistrate Khordha on 34 2021.
May I suggest one thing to
my lord?
There is certain conflict in this affidavit of the state government vis-a-vis the affidavit of the Union of India.
No,
ASI. ASI, I'm sorry, ASI. May I propose one thing to your lordship, subject to your lordship's acceptance? The chief secretary may be directed to convene a meeting in presence of both ASI and the district administration as well as archaeological department. And if your lordship will direct, petitioner can also attend the meeting to resolve the dispute amicably, so that a report can come, because chief secretary is the head of the administration. So he can convene a meeting in presence of
secretary, my lord. It is the hands with the collector.
But no, collector cannot do anything.
Collector have to
don't throw the responsibility on the collector.
Higher level.
The ASI is also to cooperate for this.
Yes, we are cooperating, but state government is.
That is what I am saying. If your lordship will direct the chief secretary to convene the meeting in presence of district administration.
Mr. Padi, what's the harm in attending a meeting?
then there is no harm, my lord. What I am clarifying, my lord, let's say visualize the position. We are writing to the collector. We don't have any hesitation to see to the chief secretary or anything. It will be resolved. But thing is, let's see the page 40 of this affidavit. We wrote a letter to the collector.
By writing a letter, nothing can be done. There is a procedure. You have to file a requisition.
Thereafter,
before the Tahsildar, you have to file a requisition. There is a procedure. Even if a government party, still ASI is to come forward with a requisition. By sending a letter, no collector or Tahsildar cannot act upon, because we are under a particular statute. We have to act according to the rules.
That's why Lordship has received the minutes. Page 34 onwards, Lordship see the minutes, which was prepared, and we have annexed in this affidavit itself. This minutes was page 34 onwards. RDC has prepared the minutes.
It is only throwing words on each other.
This is to continue, my lord. My learned friend's suggestion, your lordship may accept, and direction may be issued to the government, and there should be a meeting, including the petitioner, and that might be decided there.
Yes, that can be petitioner.
Otherwise, this will go on like this, my lord. It will never end. It will take another century to decide.
No, that is not. But all these differences between ASI and the district administration can only be resolved by a higher superior authority. That only I beg to submit before lordship.
Yes, Lordship is also good suggestion, my lord, because the RDC level we have taken. So
RDC
better
level,
the chief secretary will hold
At the government level, let it be decided. Your lordship can direct. If the direction is issued and it is not done properly, then we will come for a contempt.
No, the chief secretary will take a call and he will have the meeting in presence of both the parties to resolve the interstate dispute, and who is responsible for what, how the works will be done, whether this can be done only by sending a letter to the collector. He will send a letter to the collector, then he will sit tight. That cannot be done.
Collector is not a fashion of the ASI. The ASI is writing according to section 19 of the statute.
Because these are all private lands. Your lordship may kindly have it. There are private landowners. They have multi-storied buildings they have constructed. If we go and measure their land, will they allow us without the consent of the landowners? That is why I have filed this affidavit. That your lordship may.
That is the difficulty. 70 years after, people are coming that we are the landholders.
My lord, I may be permitted for 1 minute, my lord. There is a dispute till today. Till today, you have if you say my IA is 12,771, I have annexed at page 10. There is a demarcation of the land by ASI itself, my lord. Till today, yes.
Q. And these private landowners, they are residing there for centuries, or more than that.
Gangotri Nagar Development Committee.
Yes, my lord. If
What do
you
you
come
want,
to the
sir?
page 10 of my IA, my lord, page 10.
For centuries, they are residing there with
More than 100 years, all villagers of Lingipur are remaining more than 100 years, my lord. Have you got it, my
And
lord?
one thing your lordship may kindly keep it in mind, that so far as 775 which is within the protected area, that is not encroached, that is completely vacant. We have complied the order of the honor.
Have you got it, my lord?
Yes.
You may dispute it, but we have shown the
My lord.
We are writing the letter to the collector.
Have you got it, my lord?
Is going on. Nobody is taking steps. Now they are showing that the ASI is not doing anything.
No.
Last 10 years we are communicating a letter
Page 10.
to the collector.
You see, this ASI is demarcated in a broader line. This is the requirement. Till today, after 72 years, let the SI say how much required. You see, then I have attached the standing committee report of Rajya Sabha.
In protected area, what authority have to construct?
I have attended page 12, my lord. Page 12 of my IA. Page 12 of my IA, my lord. Have you got it, my lord?
Yes.
Kindly come to the para 12, my lord. Para 14, my lord. Page 18 of my application, my lord.
Yes.
Last para, my lord. Para 14, no last sentence. The committee recommends, my lord. The committee, Rajya Sabha, this is a standing committee of parliament, Lok Sabha and also Rajya Sabha, my lord. What is the report? The report is available in SI, my lord. What they have done on this? Report number 311, my lord. Last sentence, my lord. Committee recommends that the ministry should urgently work towards creating a regulatory framework that has provision for the least possible restriction on construction activities in the manner suitable to the specific requirement. My lord, this specific requirement for individuals, monuments, while ensuring that no structural visual damage is caused to the monument by any construction activity and does not structurally impede the right of the people. Right of the people living nearby in the monuments. I am living in 100 years. Let them tell. This is my requirement. 560 acres will not be needed at all, my lord. It will never be needed. This is my experience. This is a 1950 circular, my lord. Let them survey and decide how much require they require. Lot of people, my lord, only one thing, out of 560, more than 80% the private owners.
No. Once they have specified an affidavit that the protected area is 562 acres.
Yes.
Which means they have done that survey only, then they're telling us it's 562 acres.
My lord, this is a what is actually the need? Have they surveyed, my lord?
No, this is
in my map in page 10.
No. They have enclosed photograph of their survey operations, everything.
No, that is not there.
It is there, sir. You have not seen it. You have not seen, sir, because you only find now.
My lord, my page 10, I have given the map of the SA, my lord.
You have not seen the affidavits they have filed in this petition.
I will see
you first read
my lord, my
affidavits.
I get the copy and sheet, man.
No, you can get a soft copy. If you give a pen drive, you'll get the entire soft copy. You'll get a whole soft copy in a pen drive, sir.
I'll get
it from the court.
Lordship may take a small pen. In our original affidavit, we give a naksha. We have survey and we have demarcated the area. Also given a gazette notice of Government of India. So everything is there in the record. We have given all the records to the.
My learned friend is not going to the ground reality. The ground reality is something else. He must understand it. By sending a letter to the collector, the matter will not be solved.
I am not pressing to go to the collector or the chief secretary. I am what record says, what law is there. I am expressing the court.
No.
What I will not understand the ground reality. It is not a question here. Question is here that whether this land or not. How many persons are unauthorizedly constructed there? Then whatever area we have demarcated, whether it is probably protected or not, and who will the authority to act upon in this manner?
You say there is an issue on the demarcation of the entire extent of AC 562.681 stated to be the protected area in terms of the affidavit dated 24 December 2021 filed by the Archaeological Survey of India, packet ASI, which was referred to by this court in its order dated 15th March 2022. Stop. The stand of the ASI in its affidavit was that it can construct the boundary wall around this protected area only after removal of encroachments found within the protected area. Paragraph. Responding to the said affidavit, an affidavit has responding to the said affidavit, the superintendent, Odisha State Archaeology, has filed an affidavit on 18 July 2022 stating that except 0.775 acres, the remaining land of the protected area belongs to private persons, and that to demarcate the lands of private persons, consent of individual landholders is required. It is now suggested that either ASI should be directed to obtain the consent of all individual landholders in the notified area and file a requisition for demarcation before the Tahsildar Bhubaneswar, complying with the requisite formalities. Or ASI should be directed to acquire the notified area under the land acquisition law. Full stop. It is also mentioned that under the earlier Land Acquisition Act 1894, when acquisition was sought, when land to the extent of AC 17.181 decimal was sought to be acquired in 1992, compensation was not paid by the ASI, as a result of which the acquisition lapsed. Stop. It is also mentioned that a meeting was called for on 13 July 2022, which was not attended by the ASI. Paragraph. Clearly, the task of demarcation and protection of the aforementioned area of AC 562.681 acres cannot happen unless all the agencies cooperate. Full stop. There appears to be some kind of a stalemate. Full stop. It must be noted at this stage that Gangotri Nagar Development Committee has sought to intervene in the present petition by filing IA number 12771 of 2022, claiming that its members have been residing in the area for over 100 years, and that any steps taken pursuant to the above proposals must account for the lives of the people living in. Full stop. Paragraph. It is considered, therefore, appropriate to direct that the Chief Secretary, Government of Orissa, will convene a meeting of all the parties necessary to be involved in the exercise. That is,
Lordship may kindly indicate that
the Archaeological Survey of India,
ASI, District Administration, BDA and BMC.
Odisha State Archaeology,
Also the villagers affected.
The petitioner organization, the intervener in IA number.
My lord may say that representative, because many people nothing will happen.
One or two representatives of the
5 villages
intervener, who's filed IA number 12771 of 2022. The collector,
District Administration,
or the district and the district administration,
Tahsildar, it's all,
and the district administration,
with BDA and BMC, because they are also
the
And petition will also be.
BDA, the BMC.
BDA and BMC.
Right.
Bhubaneswar Development Authority.
Right. In the next 15 days.
My lord, it may be extended to 1 month because due to ensuing
In the
Dasara.
next 1 month.
Or
With
petitioner
advance
may
notice
also
of the
present
date of meeting being given to everyone. At least
Your lordship may pass on.
10 days advance notice of the meeting. being
Petitioner
given to
may
everyone.
represent also. Petitioner will be present there.
We have said that, sir. Petition organization.
I am obliged.
The purpose of the meeting will be to work out the sequential steps that would be be taken for demarcating and constructing a boundary wall around the protected area.
Or find out a resolution to this because your lord solution to this because your lordship may imagine there are hundreds of buildings inside that area. All are private landowners for whom Mr. Mahanti is now appearing. And all these things have to
Not
be
all
done.
of them. I think only one small area.
One village.
One bill. Total, I have calculated out of 561 acres, 82% are the private lands.
That's
and all Sthitivan, sir. All Sthitivan recorded.
Sthitivan recorded owners. That is the only difficulty. Otherwise, it's not so easy to that 775 decimal that is already vacated. These are all Sthitivan. Your lordship can imagine if a person is staying with his household for last 200
years, my lord, more than 100.
How it is
moreover,
without any acquisition, nothing. How can we abruptly evict them?
Moreover,
The meeting will also take note of all the factors, all the factors involved. Of all the, or just leave that. Let you say the minutes of the meeting, the minutes of the proceedings.
That the meeting will be everything.
Yeah,
They will
be
take
placed on record with an affidavit before this court on the next date.
and all this. Obligement.
January.
10th January.
Supplementary list item 77.
My last time, then 4/4/2022 and 29/6/2022, the government advocate had taken time. What action have taken by the Tahsildar for eviction? To the encroachers. Last two order. 4/4/22 and 29/6.
कितने number पहला?
77.
ना number कितने case number?
19,293/13.
That is 77, 78 कौन है वापस?
Baliapal.
Baliapal. After eviction, again they have included land.
Oh, that because the counter affidavit is filed since long.
No, but last time you were to find out, sir. Current status of the encroachment cases.
Oh,
25 encroachment cases.
Lordship may give me a last chance.
All right.
My lord, my prayer is, my lord, instead of arguing direct to the Tahsildar, he will evict the encroacher from the Khata number 144 within the specific date.
He will take all the encroachment cases to an logical end. That your lordship is passing orders in many cases.
I know, but are you happy with that kind of an order?
Once they have evicted, again they have encroached.
So
thereafter, the Tahsildar initiated the procedure.
Let it file an affidavit.
Oh, yes, ma'am.
You say the Mr. Mahanti seeks a last opportunity to file an affidavit informing about the current status of the encroachment cases. The affidavit be filed within 4 weeks. November 24th.
Supplementary list item 78.
May I please your lordship in virtual mode, please? My lord, the item 78 is a PIL. This is regarding equitable distribution of Mahanadi water between the state, Odisha and Chhattisgarh. Meanwhile, though the matter has been referred to Interstate Water Dispute Tribunal, but no progress has been made so far. And
so we can't have parallel proceedings here.
All
sir.
these matters are seized in that.
Yeah. The tribunal has to be seized of these matters. This is not for the High Court to deal with. Sir. All these interstate water disputes are very highly technical matters.
My lord.
You see, the subject matter of the present petition concerns the distribution of waters between the government, between the state of Chhattisgarh and Orissa, of the waters of river Mahanadi and its distributaries. Stop. There is already an interstate water dispute tribunal dealing with this very issue. Full stop. The court does not consider it appropriate to have parallel proceedings in the High Court on a matter involving highly technical issues required to be examined with the help of experts, which is what the tribunal is presently undertaking. Consequently, the petition is disposed of.
Supplementary list item 79.
If legal lordship, my lord, here I have challenged the order under annexure 2 passed by the Honorable Single Judge, my lord. And this is the second journey of the petitioner to this honorable court. The petitioner, the appellant was engaged, appointed as a UDC clerk under the Paradip Port, my lord. And he has claimed to be filled up in the post of office superintendent, my lord, for which he has filed the JC number 2049 of 1984, my lord. And I have quoted the relevant portion in the page 3, paragraph 4 of the petition, my lord.
So, petition appellant superannuated in 1990.
Yes, my lord.
1990, my lord.
1990.
32 years ago.
Yes, my lord.
My lord, he has been superannuated and the benefits were given on 8th May 1995, 32,000. That was
why you what is bringing you back to court, sir?
My lord,
what must be his age now? Above 90.
Above 90, my lord. Well, he has not yet been. This order has not yet been complied, my lord.
My lord,
They have given a promotion under annexure 1, my lord, after retirement. That page 11, my lord, with effect from backdated, my lord. Can you have a glance to the page 11 of my brief, my lord?
No. What has the single judge held?
This remanded the case to for fresh consideration, my lord.
My lord, last part, the operational part of the order.
Page 17, my lord. Page 17.
The directs the financial benefit, if any, accruing to the petitioner pursuant to direction shall be extended. He's allowed the benefit. Why have you come in and appeal?
Well, 95, he had 8th May 1995.
They have not paid, my lord.
He had paid.
File a contempt. Then you writ appeal. Writ appeal means that you are unhappy with the order of the single judge.
If any, my lord, they have written.
No. You want us to reverse, set aside this order. What is the meaning of a writ appeal? Writ appeal means you're unhappy with the order of the single judge, correct?
Yes, my lord.
You want this order to be set aside where he's saying, please grant him the financial benefits.
My lord, kindly have a glance on the.
If any, my lord, that is they have honorable just written that it is if any.
Where is it say?
And they have rejected it, my lord.
My lord.
My information today morning that.
No, but anyway, that's not a ground for writ appeal, sir.
My lord, kindly have a glance on this paper that letter.
Just ask him. This is 32 or 82?
My lord, 23, my lord.
2005, my lord.
2005 later, my lord.
After this order of the single judge, what have you done?
They have done nothing.
No, my lord, 95, they had the area.
Sir, there's an order passed by the single judge in 2020.
My lord, if.
So this writ appeal has been filed against an order passed by the single judge in 2020.
Yes, my lord.
What have you done pursuant to that order?
Take instruction, my lord.
But why should we entertain this appeal? So you should file a contempt petition if at all.
Well, kindly given him 1 week time, I will.
The court is unable to understand why an appeal has been filed against the impugned order dated 20th February 2020 of the 14th February 2020 of the learned single judge in writ petition civil 2523 of 2006 filed by the present appellant. The operative portion of the order in fact grants relief to the appellant, requiring the respondent Paradip Port authorities to direct financial benefit accruing to the petitioner appellant pursuant to the earlier directions of the court to be extended to him in a time-bound manner. Full stop. If according to Mr. Guru, the counsel for the appellant, that order is not being complied with, the remedy is not to file a writ appeal challenge the order, but appropriate proceedings for non-compliance with the order. Full stop. Consequently, the court is not persuaded to entertain the present writ appeal and it is disposed of as such.
Item number 80.
Well, this is a PIL matter, but then it appears there has been a counter filed by opposite parties 4 to 8.
4, 5,
Copy,
4, 5, and 8.
4, 5, 8.
And today I have filed counter for OP numbers 9,
9 and 10 have filed a counter
I
and
have
served a
served a
copy
copy.
today.
And today I am serving a copy to the state minutes.
Sir, again, loss of crop.
Yes, no. What happened? We have paid the amount. Now we have paid the amount. We applied as per the Government of India directives. We applied a area correction factor, and we found that when they insured, what they have shown exaggerated land. So we take satellite image, and after satellite image, we applied SCF as per the manual and accordingly calculated and paid the amount. Now, according to the petitioner, now they are entitled for more amount.
That's my grievance.
How are we supposed to adjudicate these kind of
It's a
issues?
disputed question of accuracy. Disputed question. Whether is
No disputes there, madam. Area correction factor is a satellite image, which is to be before the scheme is formulated to have an idea. That is not the actual field land available. There is a scheme was formulated after seeing this area correction factor. And after the scheme is formulated, they have to go by the scheme. Under the scheme, in a particular area approach is there. In a particular area, if the land threshold yield, which has to be calculated after crop cutting experiments, and actual yield for each year will be compared. And if the threshold yield is more than the actual yield, then the farmers, all the farmers.
Today I am filing my counter. Let my counter come to the record, Milords.
All right, the counter affidavit of opposite parties?
9 and 10.
9 and 10 we brought on record.
The other counter affidavit is copy.
We have not received the copy. 4, 5. Here
The counter affidavit of opposite parties 4, 5 and
8.
8 we filed within 8 weeks.
Now they have filed, but
Also
not
be brought on record and also be served on counsel for the parties. All right. It's done. 31st January.
Supplementary list item 81.
So this is a PIL concerning transfer of valuable portion of government land in Rourkela, ignoring statutory right of the poor and displaced persons. Earlier, the petitioner has approached this honorable court. This honorable court directed the collector to consider all such representations, and during the inquiry, they came out with a new fresh advertisement for auction of the land. That is how the second application was filed, and by interim order, the Lordship has directed not to proceed further. And specifically on 30/11/2021, direction was made to the Land Allotment Committee to file their counter. As on that, there has been no counter from the Land Allotment Committee, although the Secretary RD has filed a counter. Here, for Rourkela, there is a specific rule as to how the land is to be allotted and giving priority to the tribals and displaced. That is specifically enunciated in 5 rule in the schedule 4 of 5A rule of the Odisha government land allot settlement manual. Violating that, the RDC OP number 1 has no authority to allot land. Now he has made an advertisement. Earlier also attempts have been made and several lands, pieces of valuable lands have been heard. So that in the auction, the poor and tribals cannot compete with the rich miller. This is the way in which there is no priority, nothing has to be given to the landless person. That is how the writ application
No, but have you filed any rejoinder? There's a counter filed by only opposite party number 1.
OP number 1 has filed. I have not filed the rejoinder. The land allotment committee is the appropriate authority to say how the lands have been allotted and going to be allotted.
Who's for opposite party number 2? When are you filing your affidavit?
I have filed. Oh, sorry, sir. I'm sorry. I'm opposite party number 1.
2. On 3011, there is a direction to the OP number 2 to file count.
Last opportunity to opposite party number 2 to file a reply within 8 weeks. Rejoinder to the replies we filed before the next date. 27th January.
Interim order to continue.
Yeah, interim order to continue.
Item number 82.
Well, it's 82. I am for OP5, my lords.
What's the position now? Is that Kalinga Nagar off shop, IMFL off shop?
My lords, the shop is currently running, my lords. There is no such hindrances. And,
more or less, it has become infructuous, I think.
And it becomes infructuous.
Okay, none is appearing for the petitioner. Dismiss for non-possible.
List item 83.
Grateful.
Item number 83.
None appears dismissed for non-possible.
Item number 84.
May I please, Your Lordship? Your Lordship, may kindly have a glance at order dated 7/9/2022. On that day, my lord, the IDCO submitted that they will file the counter affidavit in the course of the day and a copy will be given to me. And that is how Your Lordship also granted me liberty to file rejoinder. They have filed the counter only day before yesterday on 19th by serving a copy on me.
All right. Rejoinder we filed for the next date. 31st January.
My lord,
interim order may
this
kindly
process, this matter is being adjourned day after. It is that DAV school matter. Your Lordship kindly have a
the
DAV school matter. It is only counter rejoinder to counter. This is going
filed
on.
it on 19th. That is not my fault.
Because our role is limited. Mainly state has to reply.
What is that with IDCO's counter? Only he is harping that IDCO's counter is necessary.
IDCO's counter is not limited. We have a limited.
They have only limited role to play. IDCO.
However, we have filed and copy also served that.
Only day before yesterday, my lord.
So what is there to counter the averments made in the IDCO's
I have to file a 48 pages, my lord. I could not take instruction.
All right. IDCO's counter affidavit is on record. Rejoinder that to be filed with the petitioner before the next date. 12th October.
12th October.
My lord, interim order may kindly be extended.
Yeah, interim order.
Obliged.
Item number 85.
May I please, Your Lordship? Here the water bodies and pond, illegally construction has been made over the pond and they are trying to fill up the pond in violation of the government rules, and there is this honorable court has disposed of a writ application in 2012 directing the DC to take actions for preservation of the water bodies, and accordingly DC has issued a instruction for ban on the alienation and construction of the water bodies. And here it is a clear-cut order shows that, and I have given the photograph in page 26. My lord, kindly have a glance. There is already a construction, and which is also the report of the concerned RI and the collector in his order clearly reflected there is a construction. which is not permissible. And now it is a well settled law by the Jagpal Singh case and some other cases that neither no alienation can be made nor no construction can be made on water body. And in violation of that, the OP number 6, who is a builder, is made construction and trying to dispose of the property in violation of all these laws on the water bodies. And this honorable court judgment is also there. And the RDC issued an instruction, and she has purchased 4 acres or out of 5 acres of that water body land. And this partial alienation is also banned as per the RDC guidelines and the judgment of this honorable court. And so the construction, all these things has been made illegally. That has to be evicted and construction has to be demolished because it is a pond, water bodies land. And in the report itself, they say that the construction has been made.
So that there is a counter affidavit filed. There is a counter affidavit. No, counter affidavit by opposite party number 6.
Yes, they have filed.
Your Lordship.
Yes,
suffice to your Lordship. If your Lordship will kindly have a glance to my counter. Now the petitioner is a mischief monger.
That is not relevant.
This is not the way, my friend.
Whether there is construction or not,
while am I
already there on record.
What about the state's counter? Where is the state's
counter? They have not taken, you have directed into state status report. They have also not taken any instruction and not filed counter.
You say counter affidavit has been filed only by opposite party number 6. The court considers it essential that the collector should file a separate affidavit, placing a record of actual position. This will be done within 4 weeks. Rejoinder to the affidavit to be filed for the next date.
Status quo to be maintained because he is trying to dispose of the property and to fill up the pond.
This is my Stitivan private property. How do you claim that a PIL is maintainable? And now you go to that extent.
It is there on record.
Simply, all those documents I have filed, you are not controverted.
That is no.
You are not disputed all those documents and also the litigation we have filed since 2011 onwards. Is continuing this petition by himself, through his sister, through his father, who is a police officer. So he should be careful with heavy.
Item 86, your Lordship has fixed it to 18th January. Item 86.
May I please, Lordship? This is a dispute regarding fixation and demarcation of a crematorium ground, my lord. Now, the opposite party 6 to 16, they are insisting for a crematorium ground on a homestead land. That is not allowed under law. For Smashan, my lord, there is a category, and if you want to convert the homestead to Smashan, you have to undergo through the process as available under section 3A of the OGRS Act, my lord. Now, they say that this will be appropriate. This is recorded in the name of a school where 294 students are reading, my lord. And just adjacent to the land, my lord, other school is there, a temple trust is there, a temple is there, government offices are there. And last time, your Lordship directed the Tahsildar to submit a report giving a sketch map. Unfortunately, the sketch map was given without the proper sketch map, my lord. Therefore, we are compelled to file the settlement sketch map which correctly show that the school is adjacent. There is no distance in between the crematorium ground and the school, my lord.
Where is your map?
Yes.
As a copy may be given.
Yes, copy we have already served. I have got the receipt.
Yesterday. It's not on my file. So
got a copy.
I am appearing for one of the party residents of that area. This is a completely private interest litigation. This person himself.
You have a copy of that affidavit.
No, we don't have that.
Where is that?
We also don't.
We don't have it.
It was filed yesterday.
Therefore, we'll have
already.
It's not.
The affidavit stated to have been filed by the petitioners. When did you file it, sir?
Yesterday, my lord.
Filed by the affidavits petitioner on 20th September 2022. We brought on record. Interim order to continue. 17 January.
The interim order to continue.
Item number 87.
This case, my lord, before the petitioners submits, your lordship, a order your lordship has already passed. I am for the state pollution control board. Your similar case, your lordship has passed an order directing the petitioner to go approach the tribunal, NGT.
NGT.
Your lordship, the same allegation, my lord, Taro River pollution and the open number 4 company has done it.
Your
Same
lordship,
allegation.
your lordship, as I may submit on behalf of the petitioner, this matter not only involves pollution, it also involves their duty under corporate social responsibility, as the prayer also mentions. And your lordship had passed an order much before, and these were not the petitioners in that case. This company has been causing
You were
pollution.
counsel there also. You were the same counsel, right?
I was
in that matter also. You are the counsel, right?
In that matter, I had not filed. My senior was there, but these were not the petitioners.
No. But
and the subject matter.
No. The counsel is the same.
Oh no, this is the last order of Justice Arindam Sinha. This was filed before under the environmental matters, and this is the last order passed. He shifted this matter to this bench.
We are talking of this. What is handed over? You give her a copy.
The other one, which
I was not served a copy of this.
Yeah. It's not opening.
Yes, your lordship. But this matter was a very old matter, and the subject matter of the present involves a duty under the corporate social responsibility as well.
It's all everybody's the same. The same company, right?
Yeah, the same company.
Why should we entertain different petitions on the same company and have inconsistent orders?
Because this matter also involves that when my clients, who are the petitioners in this, when they started agitating against this company and they put up the issue of employment also against this company, the company filed criminal charges against them. So this matter not only involves environmental matter issue, it also involves employment issue, it also involves compensation issues, it also involves...
Then why don't you separate out? Because the minute you put everything into one basket, the same problem will arise.
Sir, may I say something, Millard?
Yes.
But those persons actually put a dharana in front of the company gate. The police intervened in the matter. Police called them for a discussion. They wanted employment in the company. So that was denied because the question is they have to come through proper channel. The police called them. They didn't come. They filed successive applications denied as if it's a PIL.
That's not a fact.
But if your lordship looks at the amendment made in the writ application itself.
There's an agreement attached to the petition, if your lordship may see.
Same set of villages.
Page number 20, Annexure 4.
There, their lordships indicated you go to NGT if you want to raise the grievance with regard to
that is a different case. Page number 20 can be seen. This is an agreement letter, Annexure 4, where the company agreed that they are going to resolve this issue, but there was no further meetings held. When they approached the police station, instead, a false case, a false FIR was registered against them, so that this agitation was completely wiped off. And not only the petitioner, the whole state media, the local media, I have the cutouts of the local media, which I want to submit to your lordship. The local media has been reporting that this company has been discharging effluents since very long. This company was incorporated in the year 2004, and it started its operation in the year 2008. And since then until now, this company has contributed only a sum of rupees 50 lakh to the corporate social responsibility. It has done nothing on ground for the development of these people. So, since it has done nothing on ground for the development of these people are demanding employment. That is the least they can do. On top of that, not doing anything for the development of these people. On top of that, this company has put up its colony over there, and the waste of that colony is also being discharged onto these poor tribal people's land. The effluent discharge is going on in the river water, which is the only source of drinking water for these poor tribal villages. Now, Your Lordship, if this matter falls under the NGT, if this matter is sent to the NCLAT, where should these petitioners go? This matter involves a lot of issues, not only environment, not only the violation of the...
1 minute. So the
Yes.
environment issue you take to the NGT, because that's what we've passed in that other matter also. On the other issue, you have two, right?
Yes. The interim application, Your Lordship.
No, 1 minute.
Yes.
You're combining, the whole problem is the way you've drafted it. Both your prayers, in fact, prayer 1 is actually a combination of two prayers.
Yes.
One is to stop discharging wastewater into the river and then compensate the poor villagers. So that's the only issue then we'll entertain.
So there is no water goes to the river from the company.
Well,
No
the state
water
media
goes
is...
to the preliminary counter.
No, but anyway, on that issue, we've already said we can approach the pollution,
Yes,
the
that's right.
NGT. So that order already covers that issue.
Right.
Now, only this other issue of compensating the poor villagers. What is the
Compensation.
Yes?
No, there's no question of compensation in this matter. Actually, there is no question of acquisition of anything else. There is no land acquisition, my lord.
Oh, I see.
No land acquisition.
No,
They say employment.
No, on what is the basis for demanding this?
Under the corporate social responsibility.
No,
Your
no,
Lordship.
not suddenly. I mean, unless the
If compensation is okay, Your Lordship, I may say that in my prayer, that if compensation is not provided, at least the effluent discharge should be stopped immediately.
No, that you please go to the NGT. We've just passed that order on 20th July. You have that order, copy of the order with you.
That
Another set of villagers had come here. We've passed that order.
Your Lordship, I was the counsel that time with my senior. I'm not the counsel there, so I have no scope to again approach through that. So
that issue anyway you can take to the NGT. That will be a far more effective way of dealing with this. But on this corporate social responsibility, what's the basis for the claim? What is the basis?
The employment Schedule 7 of the Companies Act makes corporate social responsibility spending a mandatory provision.
But unless there is some...
I understand, Your Lordship. Yeah, I understand, Your Lordship. Because the activities mentioned under Schedule 7 of the Companies Act talks about eradication of poverty, carrying out employment, giving...
No, you'll have to form a legal basis for any such claim, please.
Yes,
See, ultimately, you want to help people. You'll have to form the proper legal basis for such a claim. It can't be just an emotional plea.
Your Lordship, my only prayer is for an interim stay of the effluent discharge because...
we're just presuming there is something. See, these have to be based on some factual details. There has to be an independent inquiry into it. A body has to go to it.
Your Lordship, then a direction to the opposite party number 2, that is the State Pollution Control Board.
That we've already said because they've already conducted that inquiry. You have that order with you.
Yes, I have the order with me.
Yeah, they've already filed an affidavit in that case stating clearly that there is no discharge.
This is this affidavit they had filed long ago, Your Lordship.
So you can go to the NGT. So in the last paragraph, we permitted you to go to the NGT, para 4.
Yeah,
so that you can avail of. You see, as far as the prayers in the present petition are concerned, which concerned, namely direction to the opposite party number 4 to be restrained from discharging untreated effluents into River Karo. An identical prayer was made before this court in writ petition civil 11970 of 2012 by another set of villagers in district Keonjhar, of village Nimtur in district Keonjhar, which writ petition was disposed of on 20 July 2022 by the following order. Reproduce the whole order. Paragraph. if according to counsel for the petitioner, there is still that opposite party number 4 is still discharging untreated effluents into the river, it will be open to the petitioners to approach the National Green Tribunal, Kolkata bench for appropriate reliefs. Paragraph. As regards the prayer for the villagers to be compensated, it has to be based on some objectively assessed facts, and the claim has to be based in law. Full stop. It will be open to the petitioners to first approach the local administration.
The local administration has been approached, Your Lordship.
Where is that? Show us.
The petitions, the joint petitions.
Where is that?
Annexure 1.
No,
and
if this is for again.
Yeah, Annexure 1. And again, Annexure 5. That is the thing. This private party has become so influential that the state authority is also bowing its head before it. Annexure 1 and Annexure 5 is a proof of this, that they have been sending petitions to the...
Where is this? Is to the collector, is it?
Yes, to the collector. And the copy has been served to many authorities, including even a public notice I have...
Mr. Monty,
for approaching...
Can you ascertain then what's happened?
Yes, ma'am.
This representation of the collector.
That representation.
They did not take any action.
All
Instead,
right, we'll just ask them. As far as the remaining, the other prayer is concerned, counsel to the petitioner points out that a representation was given on 9 June 2022 to the collector and district magistrate Keonjhar. Bracket Annexure 1, but no action has been taken thereon. Mr. D.K. Monty, learned additional government advocate.
a reminder on Annexure is in Annexure 5 as well.
All right, Annexure 1, Annexure 5 states that he will take instructions.
And Your Lordship, one document which has not been filed, that was a notice under Section 80 CPC for approaching the High Court of
Whether the representation has been examined or not. If it has not been examined, the collector is directed to give a hearing to the petitioners as well as to the opposite party number 4 and pass an order on the said representation.
My Lord, Your Lordship may pinpoint that which issue is to be decided by, because the other one is...
No, other one is
mentioned in
that you're not changed.
Yeah.
This is only on this whole representation.
Yes.
Is only on the promise made by the company. That's what they say.
Exactly.
No, I think that is also covered, that part.
Even the false FIRs that they have registered in order to put the agitation down so that nobody comes up and protests. Those false FIR, that has to again be quashed. We
don't know because the quashing can't be done by the collector.
Yes, exactly.
Yes. So let that be examined, that Annexure 1. And an order be passed thereon, which will be placed before this court with an affidavit before the next date. List on 19 December. All right.
Much obliged.
All right.
Supplemental list for hearing item 88.
Lord, I filed an application today. Yesterday, the last order. Last order, my lords directed the London State Council to give the written note of submission, as I was not present on the last occasion when my land friend submitted before our lordship. There is a case which was remanded from the Honorable Apex Court, where the order of acquittal was converted to this Honorable Court reversed the order of the trial court, and matter went to Supreme Court at my views, and ultimately Honorable Apex Court remanded this matter because perversity was not examined by the division bench earlier. Today, my lord, when I was preparing this matter, my lord, I found very in the paper book. I have examined the record of the State Council. These records are not there in the paper book. And I filed a petition, my lord. These pages 59, 60, 62, 64, 65, and 67, 100 to 103. I don't know whether my lord's briefs contain those papers. These are very, very important.
To take a soft copy of the entire paper book. Can't go on adjourning like this, sir. Please, today you have to start. You have to start today.
My difficulty,
We
my
are
lord.
very, very patient with you. We've been extremely tolerant. This is a 1994 appeal. We are not going to endlessly adjourn.
Kindly see this.
Whatever it is, start.
Pages are not there.
It's all right. We'll supply you all those pages, sir. Please start. Kindly start.
Next Monday, your lordship take
No, endlessly, sir.
No. This is my last.
May we make a very humble request? Your president of the Bar Association is here. Mr. Mishra, really, I just want through you to make an appeal. We want to make an appeal through you to the bar. See, criminal appeals have been pending for 28, 30 years. And these matters have been shown since which month of the year? Since last 5 weeks. More than that, sir. Actually, more than even before that earlier vacation. And every matter, every old matter, only an adjournment is sought. Only adjournments. Nobody wants to argue the old matters. What do we do? These are criminal matters. You know very well, we can't proceed in criminal matters without the lawyers. And we appoint amicus curiae. Then when the amicus curiae gets ready, the lawyer comes and says, no, I want more time. This particular matter is a 1994 matter.
No, 2012 it is only remanded. 2012.
Sir, that is 10 years after remand. What are we saying?
The last minute,
It's impossible, sir, it's just impossible to make progress. I don't know how to, what we are supposed to do. And we get a bad name saying the judiciary is delaying matters. Nobody realizes that in old matters, lawyers don't want to argue. Old criminal appeals, no lawyer is wanting to argue, sir. And it is not nice. We are ready to hear matters. Any matter, any lawyer is ready. We accommodate to the maximum. Any lawyer asking for adjournment, we keep on granting adjournments. You please, have they not granted you? How many adjournments have they granted you, sir?
Earlier occasion, my lord, I had taken adjournment, and on the ground, your lordship specifically stated,
actually, it's exasperating. I don't know. We can
only 2 days time. I don't know. Only 2 days time.
No.
Let me.
There's something for judicial conscience. So it doesn't take 2 minutes for us to say, okay, the lawyers are not interested. Why should we break our heads?
No.
But this is about criminal matters. It's of criminal justice.
The lordship take up on Monday. My lord, let me take the e-copy, sub copy, my lord, in my pen drive. These lower court records are very much required to be reconciled with the paper books, my lord. So lordship can see the paper book.
Pages are there or not?
The paper book doesn't contain these pages.
Check.
Which was supplied. And my
have you checked?
Brief also doesn't. Yes.
Have you checked? These pages are
yes,
there?
Actually, not the petition.
Yes.
I have those copies little later in my, so I submitted from those copies.
We need a paper with all these paper books doesn't contain this. You supply these copies. I don't refer to. I'll argue your lordship may take up on Monday. Let me obtain these copies from my lord's brief. I don't know whether it is there or not.
It's all there, sir. All the pages are there.
My land friend copy also doesn't.
100 to 103 is also there.
100 to 103.
Sir, just take this whole paper book. Let's not have this argument anymore. Just take the whole paper book.
And the lower court, the Honorable Apex Court judgment also, there is a judicial order to supply the copy. Because I am later on entered into, because my lord Justice, the Sangam Sahu was the...
Sir, beyond this, what more copies do you want to tell us?
I only trial court e-copies, the sub copies, trial court records, LCRs. Only seizure list and 27.
So you give a pen drive, sir, you will get the entire TCR.
Today I am taking your lordship, I undertake to take it, argue this matter next Wednesday.
You say complete paper book has been handed over.
Monday
to counsel for the respondents. He has been permitted to collect on a pen drive the entire soft copy of the trial court record. Full stop. He's still not prepared to argue the petition appeal today. At his request, list on. You better sign that, sir.
Yes, sir.
Otherwise, the same story will start. Next time, some other counsel will come and say, I don't have papers.
Yes, I'm
not required. Just give it back give back that IA. No need to entertain any IA.
may I be permitted to take the sub copy, the LCR.
It will list on. Sir, we have dictated this in the order that you will produce a pen drive, give you a soft copy. If you can bring it at 4 o'clock today, you will get it today at 4 o'clock. The court master is here. It will take us not even 1 minute to give you a copy. List on 26th. As a last chance. Right.
Item 89. Supplementary list item number 89.
We have received an instruction that another appellant, one appellant had died, another appellant, Basanta Behera. He is also dead on 9/8/2012.
All right. Learned AG informs the court that appellant number 1 and the present appellant number 1, Basanta Behera, has also expired on
9/8/2012.
9/8/2012.
So now only 2 appellants remain, my lord, Turi and Amar Pradhan.
That only leaves Turi alias Kuntala Behera and Amar Pradhan in the fray. Yes. Who's appearing for them? We had called for a report from the jail authorities.
The year of in custody, my lords? Yes, my lord, we have received that. My lord, Turi Kuntala Behera, she spent 4 years, 11 months and 13 days in custody.
No, which means they're not in jail anymore. They're not bailed right now.
She was bailed out on 10/5/2012.
All right. The
And Amar
report
Pradhan-
indicates that Turi alias Kuntala Behera was enlarged on bail on 10th May 2012.
10/5.
Yeah.
2012. And she spent 4 years, 11 months, 13 days in custody.
For Turi.
Well, hand over the copy of this to me.
I don't know. Her bail was granted on 20th May 2009 itself.
This is what you received, my lord.
She didn't come out for 3 more years. Amar Pradhan.
There's a file source, my lord, 26/2/2015. The appellant number 1 was released on bail.
Amar Pradhan was released on 10/5/2017. At least he came out in time. All right. report is that. Then we'll have to find the present whereabouts.
Yes, I do.
The IIC of the concerned police station. And Amar Pradhan was wheeled out on 19 May 2017. You see, the IIC of the concerned PS will ascertain the present whereabouts of both the appellants and furnish a report in the next day. A complete set of the paper book will furnished by the registry forthwith to the secretary, Orissa High Court Legal Services Committee, so that a lawyer of at least 10 years experience will be assigned to both appellants to appear on the behalf on the next date. The assigned lawyer will get in touch with the no, it will take off that list on 27th October.
Supplementary list item number 90.
In this case, my lord, I am for the respondent. Can you see the order dated 38/22? Last order. I want supposed to file that Supreme Court order. My lord's judgment in the division bench has been upheld in the Supreme Court. Last date, I could not supply the copies. This is with regard to the applicability of section 3D of the ORV Act. That is a bar. For contractual appointment, there will be a reservation. My lord, have held in this judgment WA number, writ appeal number 86 of 2018. Against that order, my lord's order, they have gone to Supreme Court and they lost it. So my lord's order has been confirmed. So this matter is identical. The same issue.
Where is that judgment of ours? 3rd September?
3rd September. No, 30th. Sorry. I have given that, my lord. I would perfect. And the last occasion I have one copy and just one copy I have, my lord. I have given the last only one copy. Sorry, my lord. This judgment has been upheld. Para 29/30, I have given a, this is my copy. I have given a flag mark.
But here the challenge is to a judgment dated 20th December 2019.
Pardon, my lord?
In the present writ appeal.
Yes, that issue
the challenge is to a single judge's order dated 20th December 2019.
Yes. That is another case, the same issue, whether for contractual appointment, this reservation rule is an application or not, by referring to section 3 of the ORV Act.
But there the writ petition has been allowed.
No, that writ petition was allowed, writ appeal was dismissed by my lord.
No. What I'm saying is,
these, my lord, kindly turn to my lord's judgment. My lord's judgment that
writ appeal was dismissed, correct?
Yes. That
no. But here I'm saying the writ petition has been allowed.
Yeah, issue is the same. The writ petition is, I'm the opposite party here.
Oh, you're for the
I am taking help of my lord's judgment.
Oh, I see.
Because I was also the client advocate in that case, and the writ appeal also I was the advocate. I have lost it.
I see.
That is the point.
All right.
Last occasion that my lord have pointed out to me in this point.
All right. Yes,
the issue has been set.
You're for the appellant.
I am for the appellant in one case. Writ appeal number 152 of 2021. And my non-friends are appellant in other.
In the WA 72 of 2020.
But the
rising out of the same judgment.
But so far the judgment which my non-friend refers to, that I'll go through that judgment, but I am told that is something different, a different point. What has happened in this case? Just because we want not to also, it has a far-reaching consequence. Far-reaching consequence. But what has happened, in 75 there is an act. So far, OR Reservation of Scheduled Castes and Scheduled Tribes Act. That is a 75 Act. And there is a provision, section 4D.
3D.
section 3, subclause D. There is a provision that for reservation to scheduled caste and scheduled tribe, in view of 3D, it will not be applicable to contractual appointees. Now, my lord, the subsequent development, as your lordship knows, that in the judgment of Indira Sahni's 1993 Supreme Court, then Nagarajan 2007 Supreme Court. Now all appointments are made and there are various statutory rules, including the rules on the basis of which these appellants have been appointed and promoted. Those rules have been made under Article 309. And keeping in view the judgment so far as the Nagarajan or Indira Sahni's case, and you also know that so far state of Odisha is concerned, there is a rule, statutory rule, 2013 rule, that every appointment to a civil post, so far as class 3, class 4 and group B post has to be filled up by way of contractual appointment, and the rule clearly provides that there will be a reservation. There will be a reservation. That is a very far-reaching consequence that I will address to your lordship. But so far as my case is concerned, that is not covered under that 75 Act, because my case is they are appointed under SCBC category. While the SC Act was 2008 was in force, they were not only selected, they got appointment and they promoted to the post. The lordship look to the rule, which was on the basis of which these persons have been appointed and continue for last years together. Now, all appointments have been made after 2013, all contractual appointment on the basis of the ORB Act and the ORB rules. Keeping in view the rules which has been made on Article 309. I was told that today it has been placed in the assembly. Exactly, I was told that this has been in the assembly so far as to scrap that act to 1975 because there's inconsistency so far the rules are concerned. I will show you lordship the rule on the basis of which this present appellants were appointed.
No, if you want to examine this judgment, you do that.
Yes, sir. Yes, sir, I will lordship.
Just complete.
No. So far as your lordship judgment is concerned, just now I got a copy, I will examine that judgment. But that judgment relates to a class 4 employee. And the question was, of course, I have to go through the details.
No, it relates to Shiksha Sahayaks.
Yes, sir. Shiksha Sahayak is not a scheme.
Under control of civil post.
See, that is not a civil post. That is not a civil post. That is a Shiksha Sahayak under a particular scheme. And Shiksha Sahayak, they after 6 years.
No, whereas these matters are about Anganwadi workers.
These are Anganwadis and they have been already appointed as supervisors. That is a civil post. Also, it allows her some time. I will prepare a note and I don't know what my learned friends will do, but your lordship judgment, I am sure that judgment your lordship not dealt with all these. First of all,
it dealt with only Shiksha Sahayaks.
Sir?
It dealt with Shiksha Sahayaks.
Shiksha Sahayaks. Here is not Shiksha Sahayaks. Here is appointment of supervisors. It's a civil post, admitted. And as per the rule, the Orissa Children's and Women's Welfare Service Route 1989, that I have enclosed in my case and annexed on 5.
May I submit 2 minutes?
Yes.
Shiksha, with regard to my senior, he knows it better than me. Shiksha Sahayak is also under scheme. Anganwadi also scheme. Anganwadi was regularized or appointed as ICDS supervisors. That is a civil post. Shiksha Sahayaks are regularized as regular primary school teacher. That is a civil post. All the point was dealt with by my lord in that judgment. And this section 19 of the ORB Act clearly states only 2 lines. Or overriding effect of the provisions of this act shall have effect.
No, Mr. Das, let me heard that.
No, but this is the only point. Last occasion, my senior, with all respect, therefore I have stated. He has taken time. I have given him the number. These are the cases decided. My lord have also opened. You give me the Supreme Court because on that date I could not collect their Supreme Court order. Upholding my lord's judgment. So that is, and we are the person. Kindly see the sufferings.
All right, Mr. Rautri, learned senior counsel for the appellant, seeks to distinguish the decision of this court in Sushanta Kumar Sethi versus State of Orissa on the ground that the said decision dealt with the post of single quotes Shiksha Sahayak, which according to him is not a civil post, whereas in the present case, we're dealing with Anganwadi workers who have subsequently been appointed as supervisors and are accordingly holding civil posts. Full stop. Mr. Das Learned counsel for the private opposite parties. Respondents, private respondents, contests the above submission. Full stop. Interim order to continue list for hearing on. We'll have it in January, sir.
That's the difficulty, madam. Kindly see the case is of year 2011. We are fighting out the litigation, and we have to get an appointment, and this is a contractual appointment by virtue of an interim order. They are continuing, but with the help of a single a judgment in our favor, upheld in the Honorable Division Bench, upheld in the Supreme Court. If my lord will, this is the difficulty I am facing. Kindly take note of that also.
And we have also completed more than 11 years.
No, by completing illegally, that will not have any.
The law, your lordship knows that 2013
By saying
Supreme
all
Court,
these things,
which has been followed.
it is immaterial how what will change, but law is to prevail.
2013 Supreme Court, and which has been followed by this honorable court in 2021.
And argument I have understood, because in 2013 a rule has come to appoint all the persons by contractual appointment. It will change the statute act. A statutory act. A rule.
Is required for
No. That is.
Look at the rule 5.
You argue. I am ready. I am ready today even.
All right. 12 January. 12 January.
12 January, my lord.
Sir.
My lord, may I repeat? Kindly consider.
Only getting a clear day, sir. Otherwise, it's all.
All this because it will take, because the long-standing queue of the advocates will not change the nature of the case also. And for my lord, it will take a few minutes.
I know.
So can it be now November at least? Kindly.
I don't know. May be permitted, my lord. All right. You take a chance on 24th November.
Obliged.
May be permitted, my lord, just to place.
All WA, my lord, interim order to continue, my lord.
May be permitted, my lord. Ma'am, my lord, I am appearing in appeal number 160 of 2021, my lord. My lord, here the appellant's case is a peculiar one, my lord, because I was situated on between the serial number 1 to 11. I was not made party to the original writ petition. That was my lord. May kindly see annexure 5, my lord, page 50, my lord.
No. What you want this matter to be separated out because it's all tagged along with the main matter.
My lord, it's the matter. The question of law involving is same. But my lord, my stand is that the order that was passed by the learned single bench, my lord, I was not made a party over there, my lord.
All right. Anyway, you're going to be heard here, sir. Okay, it's all right.
Grateful,
All
man.
If anyone's free, they can. And that I think he was there. No?
Continuing that, item number 6. Item number 6 of weekly list, item number 6.
I think you were to reply.
Yes,
no?
Please minutes.
This is the 304B.
Yes, 304B.
Along with 302.
302.
Yes, this is a case where the marriage between the accused and the deceased took place on 3rd of May 1995.
Item 6.
And Millard's under and Millard's the deceased died on 28th of January 1998. So therefore, Millard's, it is within the 7-year period. And Millard's, the cause of the death has not, Millard's, been sufficiently established.
This is where the
yes, Millard's. To add to that, Millard's, the deceased was hurriedly cremated without Millard's informing the parents of the deceased.
Right.
It is not that the parents of the deceased live far away or in a different state. They live in a village which is not too far from the village of the deceased. So therefore, Millard's, my first submission is that there's a strong presumption under 113B because the deceased has also, Millard's, deposed, has also Millard's informed her mother, who's the informant in this case, that she had been assaulted. And thereafter, the mother, in fact, wanted to take the deceased from her in-laws place, to which Millard's, the husband who's accused, said that, no, I will get her in some days. But then, unfortunately, in the meantime, she has expired. The defense is that the deceased died of diarrhea, but neither a prescription nor any doctor's visit nor any medicine which was administered to the deceased, nothing has been produced by the defense Millards. And Millards, I will not bother Millards, but Millards under 304B, whereas the burden of proof is reversed, there's a presumption that it is a case of dowry death. And close to the date of this unfortunate situation, unfortunate incident, Millards, there was a demand of a gold chain, which had been a long-standing demand, and that was Millards met on 20th of January 1998, where the mother of the deceased had given 4,000 rupees to the son. But thereafter, Millards, 27th, when she visits her daughter, which is 7 days later, I'm reading Millards from the impugned order, page 2. On 27/1/98, the informant had gone to the house of the accused person and came to know from her daughter that she was assaulted by her in-laws. So this is again happening in 27th of January 1998. So the soon after test, Millards, also gets satisfied, Millards, under 304B, Millards. Soon before test. So Millards, the accused, the defense had raised a argument that there was a delay in filing the FIR because on the first day the informant went to the outpost. She orally told the police officer about what had happened, and then the police officer said that you have to reduce it in writing. The next day, Millards, the brother of the informant, who's the uncle of the deceased, he had reduced it in writing and the FIR was lodged. So there is no delay, so to say, because Millards may appreciate on the first day because since the accused person didn't even extend the courtesy to the informant here, who's the mother of the deceased, to attend the funeral. So therefore, Millards, she didn't even know that whether she has died, whether her daughter has died or not, because she was informed by some other persons that such an incident has happened. So the next day when they go, so the dowry articles were also given to Millards, to the informant, which is under her zimma. So Millards, the case, Millards, is fairly, it's an open and shut, may say. But I'll take Millards to the deposition of the mother, who's the informant, which is at page 84. Millards may see.
Yes,
please. I'll start from the beginning. Jyotsna, the deceased of this case, is my daughter. I gave her in marriage to accused Sambhu about 4 years back. About 4 years back, on the day of Akshaya Tritiya, the marriage took place. There was specific demand from the groom for giving him a gold ring, a cycle, and a gold chain. Out of it, I met the demand of gold ring and cycle, but failed to meet the demand of gold chain due to my poverty. I also paid a cash of rupees 7,000 as dowry demand. After her marriage, her marital life was not happy and she was being continuously tortured by her father-in-law's member as I failed to fulfill the demand of gold chain. I heard this from my daughter Jyotsna when I visited her place. About 3 years after her marriage on Magha month, day, she was killed due to assault from her father-in-law's side members. Prior to this, she was being assaulted in her father-in-law's house on many occasions, which I have heard from my daughter. And I've also seen injuries sustained on her. Therefore, I suspected her death to be arising out of serious assault by the side of her father-in-law's house members. Para 2. 10 years prior to her death, I had given rupees 4,000 cash to accuse Sambhu, who's Millard's the husband.
It is 10
No, it's 10 days, sir. 10 days, sorry, 10 days prior to her death. I had given rupees 4,000 cash to accuse Sambhu towards the demand of the aforesaid golden chain. Thereafter, I went to her house. I saw assault marks on her and she disclosed to me that her husband, father-in-law, mother-in-law, Nanand, who's the brother of the husband, assaulted her, causing those injury. Then I wanted to take her back to my home, but the father-in-law's members did not allow her to come with me and accused Sambhu assured me, the R is missing, assured me that she will take her and live in my house 7 days thereafter, and thereafter accused Sambhu did not bring her to my house, and I heard the aforesaid news of her death, and I further heard that her dead body has been disposed of by burning without informing me. At that time, I was in my uncle's house. He went to village Dengarpadar to Dengarpadar is the village in which the deceased was married, to ascertain the matter. But without waiting for him, I proceeded to Balipadar police OP, which is outpost, and orally reported to the matter to the police. So thereafter, it is not like she was sitting on the news. The moment she got the news that such a thing has happened, she went and she orally informed the police. But the police wanted a written report, and therefore I got a written report scribed by my uncle Gaura Pradhan and presented it to the police. Exhibit 3 is the report, so and so, and I gave my signature thereon after the contents were read over to me. Because this is the for this particular, because this particular demand of dowry was not being met. My lords may then kindly go to.
No, she was assaulted by the in-laws or by the husband?
She doesn't say a particular person, but she says that in-laws members. So, and in that house, my lords, the father-in-law, mother-in-law, the husband, and the sister of the husband live. And this particular appeal, the accused, my lords, are the father-in-law. The appellants are father-in-law, mother-in-law, and the husband. These three are the accused.
No, but apart from this, is there any evidence involving them except this assault by?
No, except this assault, one is this assault which the informant has been told, and this has also been told to other prosecution witnesses who are related to the deceased. My lords may see. PW 7, 8, 9, 10, and 12, my lords. All of them have deposed with regard to torture.
Apart from the mother of the deceased, yes, do we have any independent witness?
Apart from
to speak about the assault on the deceased by the in-laws, anything other than the mother?
Please,
you seem to have a solitary evidence of the mother, correct?
No, apart from the mother, PW 7, 8, 9, 10, and 12, all of them have also deposed that the deceased had told them about the assault. If I may read the.
No, are they all independent witnesses?
No, they are all related.
I'm just talking of independent witnesses.
Independent witnesses.
Because any villager, anybody in that village where the deceased lived with her in-laws, anyone who can speak about the treatment of the deceased by the in-laws.
No, there is none on record. None was examined, but this fairly, this has not been controverted, so to say, in the cross-examination, saying that such a thing has not happened. And in fact,
that will only be in the form of suggestions. What else? Yes, they'll only say that you are deposing falsely, and that person will deny it. That's all.
Miller's, she was 23 when she died.
Whatever.
And the cause of death is said as diarrhea. And nothing has been shown, Millards, to show that she was given any treatment. And Millards, I did some research, and in fact, the Honorable Supreme Court had dealt with such a matter. And there also, Millards, the plea that was given was that the deceased died of diarrhea and all. And in that case, Millards, I wanted to place those judgments because I see similarities, Millards, as to how the Supreme Court has dealt with those cases. And Millards, on the point of hurried cremation, because if they had nothing to hide and it was a natural death, Millards, what was the need of having this hurried cremation where, Millards, the parents of the deceased were not even informed. It is another thing that they were informed, and the defense witness who they have placed and who has been examined, he says that apparently he went to the house of the informant and has spoken with them, and they apparently asked for 80,000 rupees. Now, my lords, it is on record that the informant was not at her village. She had in fact gone to her brother's village, which is at a different place. So the DW's evidence that they wanted to inform her, that also false. That is completely false. So my humble submission is that the defense here, my lords, has not been able to, my lords, discharge the presumption that she has not died. It's a case of natural death, my lords, where, my lords, assault has been proved, my lords, from the deposition of PW 11. And, my lords, this is also closer to the date of the incident, my lords. My lords, let me place, my lords, this Supreme Court judgment, my lords, on the... My lords, I have just one. Is 2004 3 SCC.
Yes.
Please, my lords. My lords, may see para 9, my lords. I'm sorry, my lords, I have just one copy. We shall now consider the evidence relevant to the conduct of the appellants. The defense case is that the deceased suffered a bout of vomiting and diarrhea and was therefore removed to Morena Hospital. My lords, in this case, she had actually been taken to a hospital. Removed to Morena Hospital for treatment. It is true that the deceased was removed to Morena Hospital for treatment on so and so. It is equally true that the appellants did not inform the parents of the deceased about her death, and they came to know about it from another source, just like, my lords, in this case. PW so and so. So, my lords, that the fact, so here also the defense was that she had died of, my lords, diarrhea, my lords. Then, my lords, may come to page 30, para 13. Shri so and so seriously contended that it was for the prosecution to prove that the deceased had died in circumstances otherwise than normal. He contended that the prosecution ought to have examined the doctor and produced the relevant documents from the hospital to establish the cause of death of the deceased. We cannot uphold this contention. The prosecution has successfully established that the deceased was married to Kalicharan about 4 years before her death. The facts also reveal that the death was not under normal circumstances. This was also evidence to show that the deceased was persistently subjected to cruelty and harassment by her husband, as well as by his parents in connection with demand for dowry, in particular the demand for gold ornaments. Once it is held that this fact stands established, under section 304B IPC, a presumption arises that it is a case of dowry death and that her husband or relatives who subjected her to cruelty and harassment shall be deemed to have caused her death. No doubt this is a rebuttable presumption, but in the absence of any evidence in rebuttal, the court may, with the aid of presumption, convict the accused of that charge. Once the prosecution proves the facts which give rise to the presumption under 304B, the onus shifts to the defense, and it is for the defense to produce evidence to rebut the presumption. The defense may adduce evidence in support of its defense or may make suggestion to the prosecution witness to elicit facts which may support their defense. Evidence produced by the defense may disclose that the death was not caused by them, or that the death took place in the normal course on account of any ailment or disease suffered by the deceased, or that the death took place in a manner with which they were not at all connected. In the instance case, if the defense wanted to prove that the deceased had suffered from diarrhea and vomiting, and that resulted in her death, it was for the defense to adduce evidence and rebut the presumption that arose under Section 304B IPC. The defense could have examined the doctor concerned, even summoned the record from the hospital to prove that in fact the deceased had suffered such ailment and has been treated to such. So, so the defense here, Millards, has not even taken her to any hospital. There is absolutely nothing to show that she had in fact diarrhea.
Okay.
So that, Millards, with regard to, that is one, Millards, circumstance.
Right.
The second is with regard to hurried cremation, Millards. That again, Millards, the Supreme Court in state of Rajasthan versus Jagbura, if I may base that judgment.
Yes.
Para 26 minutes. I have.
Yes.
The conduct of the accused and his family members in not informing the deceased about the injuries caused on her head and consequential death, and the fact that the cremation of the dead body was conducted in the wee hours of so and so without informing the parents or giving an intimation to the police so as to enable it to get the postmortem of the dead body conducted, go a long way to show that the accused had deliberately concocted the story that Shanti was suffering from epilepsy and she suffered injuries on her head by colliding against the door bar during the bouts of fits. The disposal of dead body in a hush-hush manner clearly establishes that the accused had done so with the sole object of concealing the real cause of the death of Shanti, alias Gokul.
Or
in our considered view, this was a fit case for invoking Section 106.
Yes, sir.
My lord, what evidence they could have adduced in support of the death of the disease in diarrhea? Here, my lord, it is so remote area. The police station is 25 kilometers away. The outpost is 8 kilometers away. It is from the evidence of police officers. There is no nearby hospital in the near locality also. So had they foreseen the death of the diseased, they must have taken. Who will know she will die? It is not the first case. For the first time somebody died out of diarrhea. Many people died in the year 1998. There was no latrine in the entire village.
Sir, all this you have to lead evidence, sir. See, this is the whole point. That's what they say. Whatever you want to say in your defense, you have to prove it.
We have proved.
We can't. This is a criminal case, sir. We can't just sit here and take judicial notice of something that happened in 98.
Well, we examined one of our villagers.
I know.
He is not a relation to me.
But that's it's proved to be false. The mother was not even in her own village. The mother was in her brother's village.
That is a creative story, my lord. After 3 to 4 days, FIR was lodged, my lord. Though it was stated to have been lodged on 30th, the next day, the lordship will find it was lodged after the accused person were arrested on 2nd. The entire investigation is a paperwork sitting in the police station. Your lordship may find PW7 is a relation. He stated, I marked mark of assault on the face of the deceased while he came to our house. He is a cousin brother of the deceased. This fact was not stated before police. First time stating before the court. And many witnesses have said, we went to outpost, there police examined us. But the fact remains, the police, the investigator, that is the IIC of police station has taken the 161 statement of those witnesses. This informant and his uncle just supplied some names. It appears that what I am saying, it appears supplied some names and they have been added as witnesses. And no independent witness. Everybody heard everything, but they do not say from where they heard.
3 investigators, one after another, investigated the matter. 3 investigators. Nothing could be brought to the record after the lodging of FIR. That is important. Whatever materials was collected on the same evening, hearing it from the villagers of the accused person, that is all. Thereafter, no evidence. No confession, no leading to discovery of any weapon, nothing. So only 106 is on my way.
And shifting 304B,
304.
read with 113B of Evidence Act.
At least they have not tried to manipulate some things. They have not said she died out of.
Apparently cremated herself. Where's the question of manipulating?
Not
evidence is disappeared.
Lordship, finally, yesterday I said it was not hastily. 4 hours is sufficient.
No.
And it was
without the mother coming and seeing the dead body.
And it was thought
that's so unusual. How far is the mother's village?
Mother's nearby 5 to 6 kilometers.
So you could have easily sent word for her. She could have come and seen her daughter at least.
BW2 went. There was a demand 80,000 for the song.
So that is okay, not believed. That's not believable at all. To see her own daughter's dead body, she will demand.
Someone will ask for it.
It's unbelievable. All right. Orders reserved.
I'll submit a brief note.
Yes, both. You can also submit a note.
And 302 is also, they have been convicted under 302.
All right. All right. All right. All right.